Hey guys, sorry. God, I don't have too many tabs open. I lost everything. I was trying to find my StreamYard link. All right. So, hello everybody. Hi. We've got some Richard Allen stuff to get into, and I'd put this off, and then Russell Greer crap happened, and then we had Gina Carano, and I'm like, well, we weren't giving our boy Richard Allen his due. There's a lot going on there. So I guess we'll start out with the Supreme Court issued its ruling. If you guys remember, Bradley and Rosie had gone to the Supreme Court through a writ of mandamus along with Richard Allen, saying he has the right to have his attorneys. They also filed to have her removed from the case and to set a speedy trial within 70 days. You not join mid-sentence. I was already talking. Anyways, hi guys. So let's get started with this. There's a couple of you here already. We got one super chat though. I know we need to get out of the. We need to not get out of the way because that doesn't sound fair, but we need to address it. Unhung Hero for $2. Oh, I'm gonna come. Don't come. So, with that being said, guys, if you're what the fuck am I caught on? There we go. My light was all crooked, and whopper dicked. All right. So it is time to address these things. And we got a couple of them. Yes. So, because I'm streaming so much, you can't finish the Putin Tucker interview. Yes. Bifron says Unhung Hero is consistent. Yes, he's a true and honest fan. A patron of the show, I would argue. So let's start with the Supreme Court's ruling because it's only 20 pages, and part of it we already got what we wanted out of this. So it's not bad to start there. So if you guys remember, there was a recusal motion filed, and Judge Gold said, well, now the Supreme Court said I don't have to. Well, she issued that before they issued their ruling. So this came out last week, February 8th at 9:55 a.m. I love how they have like an electronic stamp on it. That's cute. So here's case number: State ex rel Richard Allen in the matter of Richard Allen versus Carroll County Court and the Honorable Frances C. Gull. I don't know how honorable she is, but hey, she's got the title, so whatever. Good for her. The opinion by Justice Moulter. I believe that's one of the justices there. Chief Justice Rush and Justice Massa and Goff concur. Justice Slaughter concurs in part and dissents in part with a separate opinion. So remember how we said even the letting the attorneys back on was not a 5-0 decision. It was a split decision. So all this right here is going to probably be relating to whether or not he gets on. The dissenting is going to be involving this. So Justice Slaughter apparently didn't agree with the attorneys getting back on. I'm curious to see what Justice Slaughter says. So let's get rolling. This is just the beginning here. They talk about the very, very beginning of this. This is the interesting part. We'll get to the rulings here. We reinstated Rosie and Baldwin because the trial court did not find that his qualification was a necessary last resort after weighing the prejudice to Allen. Okay, and that's fine. She didn't actually do her job. They denied Allen's request for trial within 70 days because he did not make that request in the trial court. All right, and I think that's something we talked about. I mentioned that before. These other things are things he can go ahead and file in trial court. We denied Allen's request to space a special judge because he did not come over the presumption of impartiality by identifying facts that clearly show the special judge is biased or prejudiced. Well, isn't that funny how Rosie and Baldwin had it's like they knew. Whereas Judge Gold just said, no, I'm not granting it. So the facts of procedural history, we're not going over that. We already know it is what it is, okay? We get through all of that. We got to get to the discussion here, okay? Because none of that really matters. We already know the story leading up to this. If you guys don't know the story, Judge Gull remove the attorneys for what she did not like what they were doing in the case. She claimed they were negligent and incompetent, but what had they done so far? Nothing really. In fact, they've been mounting a very vigorous defense for Richard Allen. But if you guys are curious, you can go back and take a. That's a shame. Says where's Kara at? Yeah, I don't know. You haven't had time to read this? Well, we're gonna get on this then. So you finally got the notification for the members only live stream. Well, hey, better late than never. That's what I say. So here we go. All right, chat. Also, Rumble should be working, I think, out there. And let me just double check, because I'm sure somebody's gonna say, "Well, Rumble at." Yeah, Rumble should be fired up and running. So you guys should be in the ghetto working there. All right. So Allen argues the trial court exceeded its authority. The state and the special judge respond saying it wasn't proper. All right. We agree with Allen. Our court has repeatedly reviewed attorney disqualification issues through original actions, and we do so here because his petition presents a sort of extraordinary circumstances for which there's not an adequate appellate remedy our original action rules require. And I think I brought this up at the hearing when they were doing the oral arguments. And we brought this up. I think I brought this up in other points. The new attorneys aren't going to go fight to get the other attorneys on. They're going to be like, no, we're worried about our shit. Whereas if he wants his own attorney, he can't really go and do all that. He'd have to represent himself. It's a very drastic situation. So they talk about we may review attorney disqualification decisions through original action. This court has exclusive original jurisdiction to supervise the jurisdictions of by all Indiana courts. That's their way of saying this is ours. And it's only our purview. They're just making sure everybody's on the same page, like, this be our hood. These are our streets. We exercise our supervisory authority throughout original actions for writs of mandamus or prohibition. Each writ is an extraordinary remedy, equitable in nature and viewed with disfavor. And that's true. Even the judges said, we don't really want to have to do this unless we have to. It will not be issued unless the relator can show a clear and obvious emergency where the failures of this court to act will result in substantial injustice. 100%. Be issued only when the trial court has an absolute duty to refrain from acting, and original actions may not be used as substitutes for appeal. All right, and that's the issue they're going to probably hammer on with parts 2 and 3. But we got to get through part 1 first. Our court has repeatedly reviewed original actions, whether disqualified counsel. All right, and they talk about a couple of these cases here that notice these are cases nobody else, neither side talked about. State Ex Rel Kurtz v. Delaware Circuit Court. State Ex Rel Jones v. Knox Superior Court. Okay. Actually, I think we talked about Knox in a couple of the cases. Then there was Myers v. Tippecanoe County. This is where the prosecutor was kicked out. We actually mentioned that one before. We've seen that one before. And they talk about some more cases there. As in those prior cases, reviewing the trial court's qualification is appropriate. That is because this case presents extraordinary circumstances where denying the writ will result in a substantial injustice, and his petition is not substitute for an adequate appellate remedy. We reach out to Cruzen for a few reasons. For starters, Allen's counsel delayed his trial by at least 9 months, and the trial court already concluded that Allen's pretrial confinement presents extraordinary challenges. Normally, criminal defendants who are confined await the county jail, with other defendants who are awaiting trial or have been convicted and received shorter sentences. But here, for Allen's safety, the original judge transferred Allen to the Department of Corrections, which runs our state's prisons, facilities that detain inmates only after they've been convicted and serving longer sentences for more serious crimes. The special judge reconsidered the original transfer order, and she found it reasonable and necessary to ensure his safety and prevent serious bodily injury. Well, I can't trust Gull's assessment of that, given what she's done already. Allen's currently being held at the Wabash Correctional Facility. As of now, he's moving all over the place, which is hours from Carroll County. Yes, they moved him again. He's now in the area of Wabash, Indiana, where the charges were filed in Allen County, where the special judge serves. Allen's original public defenders and his substitute public defenders, they've all challenged the conditions of his pretrial confinement as they relate to preparing his defense. So that includes Lombrado and Scremin. We're in no position to evaluate the claims of those motions, but they take note of them. That's interesting. They're taking note of something that they can't comment on, but they're pointing that out. So that normally they don't talk about the record outside of what's been presented. But this is a supplemental thing that's outside the record. They're kind of throwing it in there. And the special judges concluded at least some of Rossi and Baldwin's claims about the confinement are wrong. But even assuming every aspect of his confinement is proper, and again, we are in no position to say one way or another at this point, extending it for at least 9 months still presents an extraordinary challenge for which there's no appellate remedy. Yeah. There's no way for him to challenge that. There's no remedy for him available. What's more, as we explain in greater detail below, we've concluded the trial court lacked authority to remove counsel without, one, considering less drastic options, and two, weighing the prejudice to Allen. So not only would Allen's trial be delayed for at least many months if his original attorneys were not reinstated, if Allen were convicted, correcting this qualification by vacating his conviction and ordering a second trial would produce years of delay and waste of time and resources. That would not serve, it doesn't help anybody. Richard Allen, the victims, the family, the court, or the public. Of course, these concerns can be generally resolved through interlocutory appeals, saying, hey, judge, time out. I'm going to appeal your ruling. And both the state and the judge have argued that it's a procedural route Allen should have pursued. But Allen effectively couldn't. And that's the point. Having Bradley and Rosie gone, he no longer can appeal that issue, which is why this is extraordinary. On top of disqualifying them, the special judge struck their later filings because they were no longer counsel of record. Without the ability to file a motion requesting the special judge to certify her order for interlocutory review, which she wasn't going to do, and those new attorneys weren't asking for it, why would they ask for it? Scremin and Librato have no reason to ask for it. And Allen can't file his own motion to ask for it because now he gets into hybrid representation. And we talked about that before. You either have counsel or you're on your own. You don't get both. You don't get to Hannah Montana. There is no best of both worlds. Without the ability to file a motion requesting it, certify her order, Allen's attorneys couldn't pursue that avenue. And he's referring to Bradley and Rosie. They couldn't pursue it. So, yeah, Richard Allen was hampered because of the judge. This judge she lit the fire that raged. The fire's raging right now, and she's the one who did it. To that point, the state and the judge respond that Allen, I haven't read this. I'm reading along with you guys, new eyes, should have had either his new public defenders or the appellate attorneys he retained for his original action pursue the appeal instead. But it's not clear how either option would be feasible. It's still not clear, because the new attorneys had nothing to do with the proceedings, and Allen wasn't present for them. So it's not obviously how Allen could work with his new attorneys to pursue an appeal in the trial court. Because what would the new attorney say? Well, we heard through we read news reports, or we talked to these other people. No, there's nothing to do there. Maybe Allen's privately retained appellate attorneys could have done so, but it's unclear whether the trial judge would permit them to represent Allen in a trial court along with his new counsel. Yeah, because now Allen's got appellate counsel that are running around, and well, now you've got a counsel representing you. Do you really need the people? Like, you can only have so many cooks in a pot and, cooks in the kitchen. And if they're on clearly competing interests, and I don't mean competing in the sense of Librato and Scremin and like Kara Winicky and the other guys are going to be fighting each other, but those guys are trying to go to trial. These guys are trying to get an appeal done to bring other people back on who knocked them out of the way, and then the original trial track is followed. This is, I'm talking about this, and you're trying to imagine in your head. This is a fucking mess. This is a big mess. There's no clear way how to answer this question. This is a Gordian knot, as to quote back to the times of antiquity. To talk of Alexander and talk of Hercules, of Hector and Lysander. Sue says, I've been here and commented for over a year now, and the word search trope comes from car magazines in the 80s. I'm not sure what we're talking about here. Oh, wow. Some people are trying to build towers. Kimbo says, enable big PP mode, so it's only me and you in the chats. Get a hold of me on Discord for the big PP talk. Yes, it's Lincoln's birthday today. Yes. Happy birthday, Lincoln. I just want to know how many members we're up to. 355 by the Google Analytics account. So that means I need to make more emojis. So we need to, guys, make recommendations for emojis, I guess, is what I'll say. That's what I'll tell you to do. Is it like Gordon Ramsay's knot? No, the Gordian knot is a famous knot that was found over in antiquity in the Persian Empire. And it was a knot that couldn't be untied. And if you could untie it, it required great wisdom and skill. Well, Alexander the Great pulled out a sharp sword and said, whack, and cut it in half. It's like, done. So, you want a Clyde emoji? I'll work on that. Really? Nobody liked the need a Felton emoji? Sure. I can't believe you guys, here I am trying to do like a Grenadiers March reference, and like people are just like ignoring what I talk about. Sometimes I try to be based and you guys just don't even recognize it. Okay. And it's unclear how it would work if substitute appointed counsel disagreed with the private retained appellate counsel about whether to seek certification in the trial court. Yeah. Because let's say Scrimmel and Brado were like, fuck all this. We're worried about going to trial. What do you do? How does this work? Who's in charge? Okay, we don't expect Alan to untie that procedural knot. Okay, well, we're almost making reference to a Gordian knot there, but yeah, there's a massive procedural issue. That's not his fault. And he can cut it through with his original action instead. Justice Molter, I think you and I are on the same wavelength here, dude. That's a reference to Alexander the Great. Our prior precedents pointed appellate counsel to the original action tool, and it's true. That's what Kara filed. She's like, I got to do the nuclear option. That's all that's left, and we declined to retire that tool for these sorts of situations. Now, having concluded the petition is properly before us, we turn to its merits. Alan is entitled to the obviously they're talking about, so we know that already he's entitled to the reinstatement. Disqualified only as a last resort after considering prejudice to the defendant. Yes. So this is Sixth Amendment territory, and you heard them the entire time arguing with the judge's attorney. This is the Sixth Amendment. This is a big freaking deal. He's like, oh, he wouldn't even admit, yeah, it's kind of a big deal. We shouldn't mess with it. And the judge is like, no, this is the Sixth Amendment. We're not messing with it. So they point out some things here, and this is the basic law here about you have the right to an attorney, and that goes all the way back to Gideon v. Wainwright, which is funny because the guy who secured the right for all of us to have representing counsel is from 1963, and he went pro se in the Supreme Court. His cert petition was handwritten on notebook paper. That's how cool it is. But that guarantees you through the 14th Amendment, and also guarantees you for misdemeanor charges, not just felonies. Counsel. So they point out Alan can't afford an attorney, and he's asked us to reinstate Baldwin and Rozzi as counsel. Consequently, he has no right to choose the attorneys which will represent him. But he didn't choose Baldwin and Rozzi. The trial court did. Alan just wants to continue with the attorneys the trial court chose for him. And I like how they phrase this. He's insisting on the continuity of counsel rather than his choice of counsel. Yeah. So there are issues about, this is a divided issue. Courts are divided. Courts across the country are divided about continuity, which is interesting. The continuity of court-appointed counsel. There's no right to continuity of appointed counsel out of Iowa. They say our court has been generally of the view that a trial court is limited in its authority to remove a criminal defendant's appointed counsel. And even courts have concluded there is no Sixth Amendment right to the continuity of court-appointed counsel, have agreed with that much. Colorado held that there's no Sixth Amendment right to continuity of court-appointed counsel. God, Indiana, at least like in Ohio, they number their paragraphs. So you could like paragraph 34 when you're trying to cite stuff here. You guys are making this rough. But I want to see where they talk of getting down to Iowa here. Okay, here we go. Indiana. So while the state defends a disqualification here, it appropriately acknowledges that trial court's discretion to disqualify is significantly limited. The state's brief accurately explains that while varied interests may necessitate overriding defense preference, disqualification is an extreme remedy that should only be used when the court deems it reasonably necessary to ensure the integrity of the fact-finding process, the fairness or appearance of fairness at trial, the orderly, efficient administration of justice, or public trust in the criminal justice system. Yes. So whether it's a product of defendant's right to due process or the right to counsel, the bottom line is this: a trial court cannot disqualify court-appointed counsel over the objection of both the defendant and the appointed counsel unless A, disqualification is a last resort, and B, it's necessary to protect the defendant's constitutional rights, ensure the proceedings are conducted fairly, and within our professional ethical standards. Notice they talk about ethical standards. Okay. Remember, Gold made claims they violated ethics. Well, where the fuck are they? To ensure orderly and efficient administration of justice, and those interests outweigh the prejudice to the defendant. They point out in our previous action, we said a trial court is limited in its authority to remove a criminal defendant, court-appointed counsel. But we went on to say it's necessary to explicate the parameters of that authority. And that is always an issue. The court will make a ruling, but where are the guardrails? While an original action is not the appropriate vehicle to establish or define a pose on a duty, here we do define it necessary to explain the parameters. And here's the thing. The court's like, all right, apparently we've got to make this clear now because we've got judges fucking off on their own at this point. And they're like, we're talking about you, Francis. Here we find it necessary to explain the parameters because nobody else fucking understands them. And we thought you guys all could, but apparently Frankie doesn't get the memo. The framework here just mirrors how our court has treated other drastic remedies that may conflict with parties' due process rights. Our concern is that disqualifying counsel introduced structural error, at least as it relates to disqualifying them as privately retained pro bono counsel, presents further extraordinary circumstances that prompt us to exercise our jurisdiction now to preserve the integrity of the trial proceedings going forward. Notice they're pointing out, and you fucked it up and made it. Francis, you made this even worse, so now we really have to fix it. She's made it even worse. She's like, I can't fuck it up any worse. It's already fucked up. And they're like, oh no, you went for the high score. Disqualification was not a last resort. The special judge concluded Baldwin and Rossi made 4 mistakes that demonstrated they've been able to assist the defense effectively. Securing the crime scene photos, misdirecting an email inadvertently, and didn't tell anybody. 3, extrajudicial statements making the prosecutor get a gag order, and statements by Baldwin and Rossi's record-keeping order, which turned out to be wrong. But the record does not reflect, and remember, why don't we have a record? Why don't we have a record, chat? Because the judge didn't build the record as an effective last resort. Why don't we have that? Because Judge Gold said, well, I'm getting rid of you too. We have talk about a phone call that was never part of the record. We have a brief hearing where there's nothing laid out on the record. There's no adversarial process. There just says, I don't want you here no more. I'm the judge. Ah! Imagine her being your mom, just arbitrarily enforcing things on you. Mom, you didn't, why am I grounded, Mom? You don't understand. I told you. No, you didn't, Mom. Well, now I am. So, yes, and we don't have a record because the judge fucking ruined it all. and balancing it against her effective assistance of counsel concerns against the prejudice to Allen that would result from substituting counsel. We have no record of that. She never did it because she was too busy being a fucking idiot. First, the record does not reflect because she didn't show anything was a last resort. Each of the judge's 4 concerns could be addressed through a combination of procedures and court orders, including the gag order and protective order. So they point out, look, there were some problems. You already fixed them. And trial courts maintain statutory inherent authority to compel compliance with their orders. And the procedural rules through contempt proceedings and sanctions that include even fines and jail. Yeah, she has the right to do all those things, but she did not. She didn't do this. She didn't do enough. Was that a pool cue? No. This is an Adrian Paul Boken. Back in 2021, I was going to, and future Mrs. Martin hooked me up with it. It was going to be a class with Adrian Paul, the guy who did Highlander, the TV show. And it wasn't really a, because for a while I was practicing historic European martial arts. It's what the longsword trainer is back there. But it was like fight choreography though. And I just like, it was pretty fucking cool. It's Highlander. I mean, that could only be one. So he was teaching the class and I thought it'd be really neat. She gave it to me as a birthday present. I didn't know about it. She sprung it on me. I was like, oh my God, this is so cool. Well, I found out about it after probably about a month prior to that. I blew out my patella tendon on my knee, on my right knee. I fell down a set of stairs and I tore it in half, which is really fucking painful. I didn't pull it off the bone. I tore the tendon in the middle. So no, this is really cool, but it sucks because I've got this thing and I wasn't able to go to the class. And it was the only one they've ever done recently that was nearby. So it really sucks because I've got it. And it's a thing called the Sword Experience. Adrian Paul runs it. And you guys get this as part of the class. So we weren't able to go, which is a bummer, but I've got it. And it's pretty fucking dope. And it's made out of red oak, so you know this will take a beating. And it's actually got nice wood grain. You know, they definitely looks like this one, given how the grain goes, they didn't just cut it out of the grain, cut it straight. It looks like it was heated and it was bent and steamed. So pretty cool. And it's got a nice handle on it. It's got a very grippy handle. So it's fun to play with. So that's what that is. Oh, D, we're going to get to the prosecutor's problems soon, so. Oh, Flux, you're in here? I didn't see. Oh, howdy, Flux. Hope you're doing well. It's the door, and I can reach the door if I lean from the desk. I can reach far enough to close the door to the studio, the office. And I could hear 2.0 talking, and I couldn't reach out, and I wanted to close it, but I can reach it that way, just coming back on screen. So, is your knee fixed? Yes. The knee itself is fixed, but it's been still a while getting to the point where it's back to like a full 100%, like fully walking down a set of stairs where I don't touch the rail and trust it is still an issue for me. So, not a physical therapy experience. I did. It was rough. Still kind of recovering from it a little bit. It's still like a lot of that's more mental than anything, but that happens. So let's keep going on here though. Indeed, the trial court's protective order the trial court's protective order invoked the court's contempt power to enforce compliance. You know, there was no finding that these tools were inadequate to resolve her concerns. And second, the only concern was they could not assist Allen with his defense effectively. To be sure, the Sixth Amendment's right to effective counsel imposes a baseline requirement of competence on whatever lawyers chosen or appointed. Yep. There's no suggestion that Baldwin and Rozzi are out of their depth. Baldwin's been doing this for 30 years. Rozzi has over 20 years of the same experience. Baldwin's done over 125 trials. Neither the state nor the special judge argued their extrajudicial statements. So these guys are well qualified. That counsel's statements in their motion harmed Allen's defense. They do argue the disclosure of case material undermines his defense, but they don't explain how, and that's very important. Remember, judge says, this is not good. How? What? Because I said so. Don't make me explain. I'm too retarded. And they don't argue these mistakes reflect that they're incompetent to handle Allen's defense or explain why disqualification is necessary to protect Allen's right to the effective assistance of counsel. Notably, neither the state nor the special judge direct us to any case concluding that issues like these, either in isolation or combination, render counsel constitutionally ineffective or sufficient to warrant disqualification. That's a problem for them, and they never were able to do that. Do you have a case on point? No. Third, there's no showing the special judge's concerns outweighed the prejudice to Allen from substituting counsel. Baldwin and Rozzi spent a year working with Allen, investigators, and experts developing his defense, and Allen says he's ready to present it to a jury. The prejudice to Allen begins with the fact that information and momentum spillage is inevitable in this, as one trial team hands a complicated case over to another. Yeah, information and momentum spillage. Like, you can't just run into this full speed. Add to that, Allen's already been in jail for a year and a half now, and subsequent counsel requires a 9-month delay in that date, with counsel unsure whether they would even be ready by then. That is not surprising, given it's a high-stakes, complicated case. Further, it's been 7 years since the murders. And fact-finding only gets harder as time passes, memories fade, and it's almost like they're foreshadowing. Evidence is lost. Wow, that was ba-ba-bum. Like, we got to do that one in red. Oh, no. Oh, no. There we go. And evidence is lost. Ooh, yeah. You just love to see it when the court jumps in like that. Off the top rope, and it was very unintentional, but now their fears have been confirmed. The record does not reveal any findings like that. Because the record does not reflect disqualification was last resort after balancing the trial court's concerns against the prejudice, Baldwin and Rozzi must be reinstated. Good job, Indiana Supreme Court. Allen's remaining request to present no extraordinary circumstances warning relief. The second request, we mandate Allen and his attorneys prepared and signed a speedy trial motion, but they never filed it with the trial court. Well, they weren't allowed to. Until the trial court has refused to rule properly, there's no basis, and that's the thing. Until a trial court hasn't ruled properly, there's no basis for a writ of mandamus. Okay. We therefore deny his request. Yeah, okay. You know what? Acceptable. Third is request we annoy a special judge, the appearance of bias. But Allen has not stated the facts showing clearly the special judge's qualification is required. We begin with the presumption the trial judge is unbiased. Well, not much longer, I assume, in this case. To overcome that, the party must identify facts reflecting the judge's actual bias or bias of prejudice. Okay. Our law is settled. Prejudice is not inferred from adverse judicial rulings. Well, we're past that point. And all that Allen identifies here is the adverse ruling disqualifying counsel. Yeah, well, I think we're past that point. No doubt that adverse ruling was significant, but nothing in the record. Like, they're like, look, she fucked up, and it was significant, but there's nothing in the record that suggest her decision emerged from bias or prejudice. Well, except now Willoughby. Just the opposite. The special judge explained she disqualified counsel because she was trying to protect Alan's right to the effective assistance of counsel. And we don't minimize her concerns. She faced a significant dilemma, and I think this is wrong here. They are giving her a significant out that they shouldn't give her. She faced a significant dilemma given her conclusion defense counsel was no longer effective. That's their way of saying she was fucking wrong, but she was trying to make the best decision based on her wrongness, which that's not fair. They shouldn't be they should not be giving her the out like that. She was in a tough spot either way. Well, when you make dumb fucking decisions, that tends to happen. You get into tough spots. Though we determine the record does not support her disqualification decision, we reach that conclusion with the benefit of weeks to consider the issue through briefing and oral information from excellent appellate attorneys, and the benefit of 5 justices and their staffs poring over the record, authorities, and arguments. The special judge didn't have those luxuries. Given how she's fucking ruling, it's like she's taken all fucking goddamn day on things. So yeah, I think so. Neither does Alan point to anything suggesting the judge is biased against Baldwin or Rozzi. Of course, she said their mistakes reflected gross negligence. She was concerned the representation was ineffective. But judicial marks during the course of a trial that are critical or disapproving of, or even hostile to the parties, ordinarily do not support a bias or partiality challenge. Ugh, that was brilliant. Partiality challenge. That is unless they reveal an opinion that derives from the extrajudicial source or reveal such a high degree of favoritism or antagonism as to make the fair judgment impossible. Well, I think we're at that point now where she's like, nope, I dismissed, overruled. Special judge made mistakes that rendered their representation ineffective, but her statements were not based on any extrajudicial source or experience outside the case. Instead, her statements were based entirely on her observations within the case. And while her conclusions that the counsel were ineffective was too harsh, she wasn't wrong to be concerned that the case's sensitive materials had leaked. Judges protect judges. Government protects government at the end of the day, ladies and gentlemen. They're still cutting her slack because she's part of the black-robed brotherhood. Though she mistakenly hit defense counsel's eject button instead of the case's lockdown button, that's a big fucking mistake. That's a big mistake. That may change the tide of battle still. She was right to try to get the situation under control quickly and decisively. Her efforts did not reflect any bias or prejudice, and Alan doesn't identify anything she has done that demonstrates she wasn't impartial. Yeah, she's not impartial, but I'd argue she's highly incompetent. She was grossly negligent and highly incompetent, to quote someone. Conclusion. So one of the 3 is done. Okay. A bunch of them concur. Slaughter dissents, and I want to see the dissent here. The dissent. Okay. Okay. Let's see here. Thus, I concur with part 2 of the court's opinion. Okay, I respectfully dissent from part 1. Okay. My objection is, okay, let's see what this is here, Justice Slaughter. That means his name is not start with J. That means Justice Slaughter. So if you guys notice, it's like you have J here, you have JJ. Their names actually don't start with J, and CJ is not Judge Rush's. That's Chief Justice Rush. I don't think most of you are knowing that, but I don't know which. Some of you may be coming over from I don't know, some Coomer stream. So watching I don't know, watching Boss Man Jack. We operate a little differently here. Hold on here. Have you heard about the search on 214 at Ron Logan's home? Hi, Criminal Network. Yeah, I've heard there were a bunch of searches and things were done, and we're going to get into some issues there. We're going to get into some issues here. There's a whole lot of this now. So, shout out to my boy Bossman Jack. He's going to buy a Civic one day. Yes, he'll buy a 2001 Civic with 900,000 miles on it one day. So, Richard Allen fails to meet. Okay, so here we go. My objection has less to do with the court's legal analysis than with its bottom line issuance of a writ, given the posture in which the issue of attorney disqualification comes to us. Had this issue arisen in an interlocutory appeal or after final judgment, I would be more open to Allen's argument that the trial court erred in threatening to disqualify his trial counsel after finding them negligent and incompetent. But that's not the posture of this case. But how would they get to an appeal? What, like the other justices bring up the point. You can't. It was so. This is a 4-1 decision. This is where I'd love to, like, and I'm not being an asshole. I would love Justice Slaughter to sit here and explain to me how this is going to work. Because I don't think he does that down here. Okay, but you're going to have to explain us exactly how this would have worked, because there's a lot of problems that the majority cited. So, and they talk about the same thing here. Allen fell short in both respects that the writ shall be of the trial court has an absolute duty to act or refrain from acting. Okay. And the writ can't serve as a substitute for an appeal. He agrees. He's reciting that. Okay. So let's see here. First, the trial judge did not file an absolute duty in dismissing counsel because Allen does not have an unquestioned right to keep them. Okay, so he's going the Sixth Amendment protects Allen's right to counsel, and he's citing Wheat v. United States, which includes his choice of qualified counsel. All right. The right to counsel of one's choice, though, but is not absolute, but is circumscribed in several important respects. Yes. Trial courts have wide latitude to balance this right against competing interests like fairness or professional ethics standards. All right. Yeah. He's reiterating. Okay. While the trial court's actions raise a potential constitutional problem under current law, it is far from clear she exceeded her authority. If it's not clear she had the authority, that's a question. And this is, I don't like a judge. This is, I said most judges are risk averse, and that's sometimes a good thing. This is where it's a bad thing if they're not risk averse. Well, it doesn't say she can't do that, so maybe she could. No. If it's not clear, the expansion of power of a government agent should be heavily scrutinized and should be cautioned against, if at all possible. The court's opinion tacitly admits as much. To justify its award of relief, the court must fashion a new rule against which to adjudge the trial court's actions below. A trial court can't. Okay, and they talk about those interest prejudice, and he recites he's citing above. And then having announced a new rule, the court proceeds to find the trial judge breached it. Well, that's what happens when new shit comes about. The court has to make rules, and sometimes it sets new ground. Nobody thought this was ever going to happen. I'm sure if you would have asked these judges 6 months ago, would this have happened? They would have looked at you and said, "What are you, a fucking idiot? There's no judge in our state that is that retarded." And then here comes Francis Gull, says, "Hold my beer, y'all. Let me show you what I can do." And she sits and spins right on the keg tap in front of the whole party. The problem is that this rule did not exist previously. That doesn't actually mean anything. Sometimes new rules have to be made. The opinion cites nothing from our court or any court establishing this rule. This is something that's never happened before. This is truly uncharted territory. And why would you not want to caution on the side of a defendant? Yet, despite being unable to identify the source for which the rule imposing the supposedly clear legal duty, you don't have any, there's nothing on point for this. The court's not even sure the rule's constitutional source, be it the defendant's right to due process or the right to counsel. The existence of such duty is anything but clear if the court must patch together its rule out of whole cloth. Oh, yes, and that's the thing. It's a ruling made out of whole cloth. They're just making it up. I think that's a bit dramatic there, Judge, given the fact we're dealing with some serious shit here. On the merits, I do not necessarily quarrel with the rule the court announces today. It appears to strike a reasonable balance between the competing interests of a criminal defendant's right to counsel and a judge's right to ensure the defendant receives a fair trial. My beef got beef! Got beef! Rather, it's with our after-the-fact application of this newly minted rule to award mandamus relief against Judge Gull, who did not have the benefit of our rule when she acted. Justice Slaughter, if you happen to watch this, there are a lot of things Judge Gull could do right now that you guys haven't made rules against. There are a lot of things she can do right now that you guys don't have rules against that would be actually fucking insane. Like if she made it a rule that Richard Allen had to get sodomized with a plunger in front of the jury every morning before the court started. Do you guys have a rule against that? Well, no, we don't, because it'd be insane for us to have to. But you don't have a rule. Okay, so if it happened, would you make a rule against it? Yeah, you would. The fact you have to make a rule and the fact the rule didn't exist previously doesn't mean what happened right now is not improper or shouldn't have been addressed through a rule. It's just we never thought anybody was going to do this. Nobody was dumb enough to even think that they can do this stuff. So it's not the fault of the court system. It's the fault of Judge Gull. For this reason, and she can't say, well, I didn't know I couldn't fuck him with a plunger in front of everybody. There wasn't no rule to tell me not to. I'm just simple judge, lady. I just come out here and sign some papers and bang my hammer on the tables. That's all I do. Yes, sir, yes, sir, yes, sir. It doesn't work that way. For this reason alone, I cannot join part 1. Our original action rules do not permit issuing a writ when the trial judge's duties are unclear or the law is unsettled. It's because this has never happened before. This has literally never fucking happened before. Because nobody was that asshole-ish or stupid to do it. It's never happened before. Original actions that are clear-cut for cases today applies to the law are not for cases like today's that announce new legal rules. That's what the latter is what appeals are for. Okay. Second, Allen does not make the case an appellate remedy would be inadequate. This case should have been brought in an ordinary appeal. Oh, so he gets convicted and then deals with it. Instead, by issuing a writ, we ratify Allen's improper request to shortcut an appeal on the merits. Allen could have sought a discretionary interlocutory appeal, under Appellate Rule 14. When the judge dismisses counsel and barred them from entering a pro bono appearance, there is no reason to presume Allen's original action counsel could not have pursued such an appeal on his behalf. How? They're not counsel of record anymore. Judge said, I'm not allowing you to be here anymore. Certify the order. I'm not letting you do a goddamn thing anymore. So this doesn't work. And had Allen refused the request and had Allen been convicted, he would have the ultimate appeal remedy, automatic reversal of any commissions based on the claim the judge's qualification of counsel amount to structural error. The fucking balls on you. I guess, I changed my mind, Justice Slaughter. You want him to fucking eat your conviction and start over again in 7 years. That's what it'd be. It'd be like 4, 5, 6, 7 years down the road. Oh, oopsie poopsie. Like, what the fuck, man? Go spend 7 hours in jail or prison. Like, dude, it doesn't work that way. Like, you can't just sit there and go, oh, it's no big deal. Well, who the fuck are you to say it's not a big deal, man? That's not fair to you. That's the part I hate. I don't hear judges do this, but you hear parties, like, especially prosecutors, like, oh, it's only a little bit of jail time. It's like, you ever been in jail? It's not fun. No one likes to be there. That's not, that's the problem here. So you go, oh, it's no big deal. Fuck you, man. There's no other way around this. This judge has baked it in and intentionally torpedoed everything. Um, you know, there's no way around this. Um, hold on here. Oh, I got a sorry guys, I got a update on a continuance here. Okay. Sorry, I got to put this in the calendar. Color green. Well, I guess I'm not doing the Ruby, Frankie, and Jody Hildebrand sentencing, guys. I've got a hearing that got scheduled for a client who's in prison. We're trying to get some convictions overturned. So I will not be available that morning on February 20th. So programming note now. Either appellate remedy or interlocutory appeal after final judgment would have provided Alan all the relief he was entitled. Fuck off with that. That is bullshit. It's okay, dude. Just take it in the ass. Just take it in the ass. Just take it in the ass, Richard. It's okay. Just a little bit up the ass. You'll be fine, brother. Some people. I live in constant fear of getting called out in an opinion. Yeah, just do what you got to do. This is just. Yeah. Where's the beef? Inmates would hook me up with some cornrows if I went to jail. Yeah. Oh. Finally, the court rationalizes its writ by claiming we repeatedly reviewed attorney disqualifications and original actions. You have, and you basically always deny them. Our case law does not bear out a pattern of issuing writs. That's not what they're saying. We've reviewed them. Of the many cases the court cites, we issued a writ in only 2. Yes. And one of those who disqualified a special prosecutor's appointment of violated statute forbidding the appearance of impropriety. The other would disqualify an attorney whom a state agency hired in violation of a statute requiring the attorney general to represent the agency. Okay. Unlike here, both cases involved a violation of a clear legal right or duty. Are you sure about that, Justice? I mean, really? And but for the writs, counsel's continued representation would have exceeded statutory authority. The court today flouts our original action rules to award extraordinary mandamus relief, or mandamus. I think it's mandamus relief in favor of Allen against a trial judge. Why do I say mandamus? Because I am from farm country in Ohio, so it's mandamus, just like it's Versailles or Greenwich, as the names of towns. Wasn't it called Versailles? Not in Ohio. In doing so, we allow Allen to short circuit the appellate process, muddy our own jurisprudence in this important area. Really, is it that muddy? Because I don't see any other. I think it's pretty clear now. Judges are like, well, if any of you were dumb enough to try this again, you can't fucking do it. And invite future deviations from our rules. In my view, these institutional costs far outweigh the benefits to Allen. For these reasons, I dissent from part 1, but I agree with part 2. And notice, it's interesting they list out for part 2, they went forward and laid it out in argument. Because normally when the court finds reversible things, they stop. But this was such a big deal. They're like, look, here's what we're doing. Here's not what we're doing. But I disagree with Justice Slaughter completely on this. I understand. And I understand his concern that he doesn't want to open the doors to everybody. But this isn't going to open the doors to everybody. This is about as bad as it gets. Short of the judge like sodomizing him with a plunger every morning in front of the jury. I mean, like, what more do you want to have happen here, bro? And I say the bro part with like actual, like niceness here, bro. What do you want happening? Matt says, let's not pretend that more than one Ohioan has heard of Versailles. Oh, well, Versailles have one of the best football teams in the country. It was one of the best small school football teams at least in the Midwest for like almost 20 some years. So, defense attorney in the Fanning hearing has massive knockers. I don't know what the updates are on that, but it sounds like they lowered the boom. I know Joe covered a little bit of it, but that'll be something probably to cover on Thursday. So, Sean is a real lawyer. I try to be, Kaz. I try to be. I file these writs not for honor, but for you, continuance eater. Yes, Versailles, Ohio. Didn't even know that existed. Yes, it does. And then there's Greenwich, Ohio, but we call it Greenwich, and there's a bar called the Green Witch. Yes. Lesko says this got gay rather quickly. Rather quickly? Like, it didn't start out that way? So Joe's covering some stuff there. Well, we'll probably get to it. Maybe we'll look at it tonight a little bit and cover it up. But also, guys, want to remind everybody on Locals tonight, 8:30, we have the Monday show. Get to hang out, have a lot of fun. If you guys want to join, it's over at potentiallycriminal.locals.com. It's at 8:30. 1 month free, and use the promo code now, criminal 2024, and you get 1 month free if you guys are interested. But without being a supporter, you don't get to watch the show. Well, you get to watch like the first minute or two, and that's it. So, yeah. So I just want to let you guys know tonight at 8:30 we'll be doing that. But we got to get through the rest of the Richard Allen nonsense that's going on. Once I started singing, it got gay. Well, it's been gay for a while because I've sang a lot. Okay. So, since all this has happened to the state has argued for a motion of contempt against Bradley and Rosie. That is one of the other major pending issues. And this one is very interesting. So the defense has responded. And once again, the state has basically aired all those things that were cited. The gag order, the emails, and the pictures. And oh my gosh, Judge, he makes my tampons get cloggy. That, the prosecutor in this case, Nick McClellan, is just a sobbing little girl at this point. I think he's got some issues as well on his own, but we'll get to their problems coming up. So Rosie and Bradley are getting ready for this hearing about contemptuous conduct. So it was filed on January 29th. So after everything had been done and they're back on the case, the prosecutor goes, "Well, I'm gonna file this motion." So they fire back immediately, and this is through. You guys notice this is written differently, and once again, God Almighty, why don't people use justified alignment? Straight on the edges, it is the way to do it. Oh, makes me twitch. Even in the footnotes, oh my God, you could like clean this up so much. Oh, savages out there. Makes my eye twitch just a hair. So there's an attorney. A new attorney jumps into the, representing Messieurs Baldwin and Rosie. Want the IE on the end. Attorney Michael Osbrook, okay, who is from the Indiana School of Law, part of the Federal Habeas Project. Which, if he's doing a project, means he's actually, this isn't just some douchebag professor who does some law review articles. This is a guy out there. This is a practicing lawyer. Habeas stuff is, you got to go to court for that. So good. They got a well, I haven't read this yet, but he should have an idea what the hell he's doing. So what's wrong with this? What was wrong with the state's motion? Well, it fails to allege either directly or indirectly that any of the supposed offending acts are willful. Because you have to be willful to get sanctioned. Or be held in contempt. Like, if you mess up, it's like, okay, but that's a problem. There's two additional flaws that are fatal. First, to extend the state's information purports to allege indirect civil contempt. It fails to allege any act injuring the state that a remedial or coercive contempt sanction could redress, saying, don't do it again or you're in trouble. The state lacks standing to pursue its information as one for indirect civil contempt, and the court lacks jurisdiction to consider it. Yes, if your remedies have not been extinguished or exhausted, you can't ask for more drastic remedies. There's no available remedy or coercive contempt sanction. Any sanction would be punitive and therefore a finding of direct criminal contempt. But to file indirect criminal intent, the state would have to file, to pursue indirect criminal contempt, the state would have to file its information in a separate criminal case. And it hasn't done so. So they're not complying with the rules. And this court has no authority to punish them for criminal contempt in this case. So they're just pointing out, procedurally, this is not being done right. You haven't exhausted your remedies, and now you're using something that doesn't work. Finally, where the court imposed jurisdiction without its authority to do so. Any punitive sanction on this information would at least be the second time the court has interfered with Richard Allen's 6th and 14th Amendment rights to counsel. Oh, yeah, they'll be like, Judge, it's the second time you fucked with it. So let's get going here. As a matter of law, almost older than dirt. Oh my God, that's... Oh, I haven't read this, and this guy's going to talk a lot of shit, I have the feeling. There are two kinds of contempt, indirect and direct. And this is going to break it down, and that's actually helpful. Because I think you guys, it'll help to explain it. Indirect contempt, which is at issue here, involves acts committed outside the presence of the court, which nevertheless tend to interrupt, obstruct, or prevent the due process of administration. Okay. It should not be a matter of dispute the state's information at least attempts to allege Baldwin and Rosie committed indirect contempt. None of the state's information alleges the contemptuous acts occurred in the court's presence or about the court, which the court itself has knowledge. And that's the thing. None of this happened in court, which would be a direct contempt issue. The press conference, the leaked pictures, the email, all this stuff is outside of what's going on. Let's see here. Outside the court. Direct contempt depends on the judge possessing personal knowledge of the contemptuous act. And none of that happened in front of the judge, so she has no direct knowledge. There's a God, this is a long, wow, this is a big footnote. These are massive footnotes. Okay. Wow. All right. Wow. Okay, that's okay, so there's going to be a federal habeas issue here they bring up. Okay, so when this is talking about when the judge ordered them to stop their work on Mr. Allen's behalf on October 12th. That violated his right to counsel. Okay. And this gets to what's called the younger abstention doctrine. Okay. State interference with his lawyers could well compel Allen to seek a federal habeas relief under 28 U.S.C. 2241 in the form of an injunction. Were Mr. Allen to prevail in that undertaking, and this is because this guy's a habeas guru, so he's using his habeas knowledge. They're using more formal legal language. It would look something like this. The judge would say, the federal judge would say, release Mr. Allen or leave his lawyers alone. But win or lose, federal court is not a railroad siding, which Chief Justice Rush likely had in mind when she said getting the second hearing was to get the case back on track. Okay, that's a complete dad joke in court. That's boo, 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 boo. Yeah, he's going deep, but oh, Nick is here. Hey, Nick, how you doing? Yeah, he's the director of it. Okay, okay. Oh, I thought you said he is shit. He is the shit. He's one of those people who can recall a random obscure case off the top of his head. You could sit and talk shop with him all day. Well, maybe I'll try to ask to talk to him after this is over. Matt says true. Most word processors don't do alignment correctly. I mean, you gotta format it and fuck with it, but you can't. Like, just look at this garbage. Look at this. It's like, bleh. Like, no. No. And actually, Nick, if you went on, I'll send it to you if you'd like to join me. I know it's getting late over in Sverga, but you can join if you'd like. There, I just sent it to you if you'd like to join me. But just look at this. Is just fucking disgusting. And this, what, like, I feel like I'm Gunnery Sergeant Hartman in a Full Metal Jacket. What the fuck is that? Anyway, as a second matter of law, almost older than dirt. Direct and indirect contempt come in two varieties, civil and criminal. Sanctions for civil contempt are for the benefit of the party who's been injured or damaged by the failure to conform to a court order. Civil contempt must also be either remedial or coercive. Civil contempt's the enforcement or protection of the rights of the complainant. And the complainant, I mean, who's complaining about this issue. And only coercive or remedial judgment may be entered. So it all depends on what you're going to do. That's, you might limit discovery. You might enforce, like, the party can't do this anymore. There are no, it's very basic things that the court will say, don't do that again. You can't do this. Don't talk to that person again. There might be limits to what can be done discovery wise, or like, we're going to monitor it, or anything like that. Criminal contempt, on the other hand, is an act directed against the dignity and authority of the court, which obstructs the administration of justice and tends to bring the court into disrepute or disrespect. So these sanctions are intended to vindicate the authority of a court. Where if like we've seen, you go in there, fuck you, judge. Well, now you're in contempt of court. That's criminal contempt. We're trying to the court is asserting its authority over you through sanction. Oh wow, did he just kind of skip through? Okay. The court's state's information alleges no injury a civil contempt sanction can meaningfully redress. And the resulting lack of standing to pursue its information means the court has no jurisdiction. So this is an issue of Darrell Brooks. Is this a court of appropriate jurisdiction here? Yes, I think we're at that point. So, Mads is saying everybody should be nerdy and Maxley out and do like physicists and math professors do using latex. Look at their papers and see how beautiful the formatting is. Well, it's not just the formatting for me. And I've said this before. It's not, Not to do my Joker. Yeah. It's not just the formatting for me. It's also the citations. When I see a Chicago citation, I just think that's a man of culture. It's somebody I just want to reach out to and say, brother, I've missed you all my life. Where have you been? And then for those people who use Turabian, when you use Turabian formatting in your citations, I truly think you're one of God's children. I mean, you are one of the benevolent ones. You are one of those innocent men that God asked Lot to find before he laid waste to Sodom or Gomorrah. But my father wasn't one of those men. My father liked the APA and MLA citation formats. And one night, after he beat my mother, he looked at me and he said, I can't do it anymore. Oh. Nick Storrow, how you doing, man?
I'm doing good. I'm having a few days off, and I got curious about this new lawyer, so I started to Google, and he's one of these silent ones. No social media presence, no nothing.
Yeah.
No, not a profile on
work.
Yeah, he's actually doing work.
He's also a normie, I assume.
Yeah. And the little I found, first of all, he's not only a part of this habeas project, he's the director of it. And he teaches judges on habeas. This
My
is
impersonation needs the Heath Ledger. Fair enough.
This is a heavy hitter. This is one of these you never hear of them.
Yeah,
but
it's just like Kara Winnicky. You never hear about her, but she's in the she's part of the League of Shadows. She's just in the background taking care of business.
Yeah,
shoving knives in the back of people's skulls. They're the ones out there doing hits, and you never hear about them.
Yeah, not always. All of us have the weaponry. Yeah. This entire case is bonkers.
It is. And
now
we haven't gotten to the lost evidence part yet.
Yeah, I read through that, and it's. Are you past 2 hours? No, you're not. I can't. No, I can't.
Don't worry. We'll when we get to there, I'll let you say whatever you got to say.
Yeah,
if you want to really say it ahead of time, though, that's fine. I get like limited ads anyway on everything nowadays, so. Yes, you can't unfuck a clusterfuck. Oh, I've already sworn, so you're fine.
Okay. Yeah. This case is a clusterfuck because all of a sudden there are these silent people in the background who all of a sudden gets involved. Now things are getting serious because now we have this guy. He went to uni 1983. He graduated from law school 1993, so he did some work in between as well. I can't find what, because he has no social media presence. He has a LinkedIn page with basically no information on it.
No information? Oh.
Yeah. And then this uni, he is a part of the habeas project. Yeah, he's the director of it. He teaches judges on habeas. I mean, now the heavy hitters are coming out. The silent ones are getting involved.
Oh, yeah. Everybody's getting involved.
Yeah.
Lin Singh, why would it have been a practice trial the first time through? Because his Sixth Amendment right to counsel is such a critical foundation to a trial.
Yeah.
That if his right to counsel is violated, it's considered structural error. It's an error that's structural. Think about it in the terms of structure. Like if you built a house and the foundation was bad, or if you started building a house and you left it sit outside for like a year. Let's say that happens. Yet the house sits outside unprotected for a year. The frame gets weather beaten.
Yeah.
It might start rotting apart, and you try to build a house around it. That house is a structural error to it. What does that mean? Well, the house can't stand. Well, a structural error means you've got to tear it all down. You can't gloss over it. You can't say, well, he was guilty anyway. No, his right was violated so badly. There is no way to address it other than giving him a new trial. So that's the issue.
Yeah, and I'm still amazed there was not.
Oh. Well, that's a new type of meta construction. You build the house within the house.
Yeah. Now, for instance, when I raised the roof to build a second store on the house, I started with checking the foundation. Does it hold?
Yeah.
I mean, you have to do that. And
yes.
I'm still amazed that it wasn't unanimous to reinstate the lawyers. How anybody could. But I'm not American. What do I know? But from the people who have been commenting on this, who are actual lawyers, are equally amazed.
Mm-hmm. Well, I don't know if you saw, but last week I had on one of the attorneys that helped get the action in front of the Supreme Court, and she even said she had no idea this case was going on, but it was once she learned of the nonsense, she's like, I have to get involved.
Yeah.
So, because otherwise it's no different than any other murder in the state.
Yeah. And that's also something people actively is getting involved in this. They don't have to ask for it. People, okay, I need to be in on this because something is really rotten here.
Mm-hmm.
And
Whiskey saying in Sweden, don't you guys have dirt floors?
That's out in the barn.
He must be in Norwegian.
I mean, at what point does the prosecution and the judge start to realize there's a lot of heavy hitters here? Maybe I fucked up.
She can't back down. If she backs down, like there's, you know what I mean? The cake's already baked. She can't back down. I mean, if she, if you back down, you give up. So
if she backs down, her career is done.
Well, no, it's not her career is done. It's just that is a big hit to pride, and it's just like any normal. It's think of it as a normal person on the internet when they crash and burn. If you back down, you open yourself up. So, but
is that a politician started with a couple of decades ago? Never apologize because it shows weakness.
Yes, this is the one place though where it's a little different.
Yeah, I mean, judges. I mean, have a tendency to protect each other because of the notion. Well, we're judges. The position is to protect it. Yes, the position, not you. You are there temporarily.
Yes.
It's the position that needs protection. And oftentimes from themselves.
Yes. All right. So with that, we have to get to this scholarly man who's pointing out that you have to follow the process and the procedure for contempt. That no sanction for any of the alleged contemptuous acts would remedy an injury to the state, nor would it coerce Monsieur Baldwin or Monsieur Rosie. And I keep pointing out to people, so you say Monsieur as in plural, to comply, because that's too many S's if you spell it out.
That's how you know a scholar is involved.
Yes.
It's not Baldwin or Rossi. It's Messieurs.
Yes. Yes, to comply with any or the state's information they allege that they violated. The state has no standing to pursue this information. The standing requirement is a limit on the court's jurisdiction, which restrains. And normally, yes, you hear Robert Barnes talking about standing being a nonsense thing. This is different, though, because it's in a criminal setting where standing is jurisdiction. Okay, basically, there is no jurisdiction here. There is no standing. That this is not the right thing. The state doesn't have the right to seek this action. And then, this is here. Only persons who have a personal stake in the outcome, and the state has a personal stake in the outcome, they've suffered or are in immediate danger of direct injury, will be found to have standing. Well, none of that shows direct injury. Most of this that they claim is effective, like it's going to prejudice Richard Allen, which means that's not their problem. They can't be filing the motion on his behalf anyway.
Yeah.
Without an injury meaningful redressable without an injury meaningfully redressable by a civil contempt sanction, the state does not have standing to pursue its information. And this court does not have jurisdiction to consider it. Accordingly, the court should summarily deny the state's information. Okay. The state can only seek punitive sanctions for contempt. It filed in the wrong place, and this court has no authority. So they keep pointing out that they've done the wrong things. They filed it in the wrong place. As a third matter of law, almost older than dirt. I love that.
That's shade.
Yeah, and that's just saying the fact I have to say this is a bit, I guess I'll say something that we all know.
Yeah.
And that everyone knows. A sentence of imprisonment is punitive and criminal if it is imposed retrospectively for a completed act of disobedience, such the contemptor cannot avoid or abbreviate the confinement through later compliance. Meaning, it's punitive if I can't remediate the problem. If you're going to punish me for conduct that I can't avoid or abbreviate through compliance. And that's why when we see contempt hearings, guys, the attorneys or that party will purge the contempt. You have the right to purge contempt even in a criminal setting. Maybe it's offering an apology. Maybe it's writing that 20-page paper. Maybe it's paying the fine. Maybe it's taking your colleagues out to lunch. Maybe it's whatever the judge orders that's within the rules. But that's where it comes from. Similarly, a flat unconditional fine totaling is even little $50 after a finding of contempt is criminal if the contemptor has no subsequent authority to reduce or avoid the fine through compliance. And I've seen, attorneys get late and the judge has one finding you $50. Now, normally most attorneys are like, okay, fuck it, I'll pay it. I'm sorry, judge, I'll take my lumps. Because you don't normally go appeal a $50 fine because, well, that judge already fucking hates you and you don't really need that on your, you don't need that on your plate. But I've only seen it once.
I think we are past that in this trial.
Yeah. Well, I was going to say, Nick, I actually saw a judge once. He's a visiting judge. He's an old judge. He used to run the courthouse. When he was late for he was very big on being on time. And one time he was late by like 10 minutes to court for a hearing. And he said, I'm late to court. I find myself in contempt. I don't think this is actually legal how this would have been done. But he was on the record. He's like, I find myself in contempt. And he's like, I find myself $50 and I will pay to the court. And once I pay and have receipt, I will provide counsel for the state and the defense notice. And
if we find that record, I will send it to the young thug judge.
Oh, okay.
28 trial days should all have been started at 9:30 a.m. He has not once been less than 25 minutes late.
Yes. Well, here's the deal.
Yeah, he has PTSD and he has his support dog and everything.
He has a support dog?
Yeah.
What does he have PTSD from?
He was a judge over in Afghanistan as well.
Oh, he was a JAG attorney. Okay.
Yeah.
Okay. Well.
Yeah, he was there to build up the new Afghanistan justice system. I think he did a great job, don't you?
Well, I mean, like, it's, that's, as long as he was telling them, like, no, you can't throw rocks at whores. That's not a legal remedy.
Yeah, don't throw gays off buildings. Don't throw rocks at whores.
Yes. I have a two. Je parle français un petit peu. So not that much. It's okay. Something about this applying in France. That's about all I got. So I don't know.
I haven't read French since I left the European. Yeah, I was a document analyst in the European Parliament. I hate French.
Okay. Well,
the language, the people are decent.
You were part of the Miracle Reich for a while. You were.
I was just a documents analyst. I actually didn't do much.
I just filled out the spreadsheets for the trains. It's okay. I didn't do anything. Okay, so an information for criminal contempt must be filed as separate action. As a fourth matter of law, almost older than dirt, if the state by its information, this is seeking punitive sanctions for direct criminal contempt, it filed its information in the wrong case. A proceeding for direct criminal contempt must be filed as an independent action and must be prosecuted by the state.
Oh.
Now, this is under state law they're citing, so this may be different in other states, but in Indiana, this is 1963, 2004, 1990. It's been established.
Yeah.
Charge of contempt should be prosecuted by the state against the defendant in an independent action. Okay. The information should be titled "The State of Indiana versus the Defendant." So they've ruined this.
Yeah, he's. I mean, he teaches judges, and now he's teaching a judge.
Well, he's teaching a prosecutor too.
Yeah, that too. Yeah.
Yes. The court may not impose any sanction for what can only be a finding of contempt in this case against Mr. Allen, and that's correct. Richard Allen could be held in criminal contempt in this case, and they don't have to file a separate action. That would amount to a conviction and punishment on a charge of the state is not made. Okay, the situation would be no different than that of McMinn. Okay, McMinn was not convicted on a charge not made, which is sheer denial of due process. Okay. I've read
1937, 94.
Yeah, it's an old U.S. Supreme Court case. Thornhill v. Alabama, though, I know that one. Therefore, the judgment and commitment issue are therefore void. Johnson v. Zerbst is one I know. That's one I'm familiar with. But yeah, DeJong, I don't remember that one off the top of my head at all, but I know it's something I probably read. Accordingly, for the second reason, the court should deny the state's information. Not only the state's wrong place, but it also fails to make out a criminal charge. It doesn't allege that they acted willfully, which is a big deal. This is not remedied by any reference in the information to the statute, which defines indirect contempt as willful disobedience of a court order. Okay. And yeah, so we're at the end. So that was Baldwin and Rosie. I wonder if they hired that or if that's somebody just tapping in for free who wanted to.
The information I saw is he's an adjunct at that university, and he does do a pro bono. So I think he just took this on.
Yeah, well, a lot of attorneys get involved in this. A bunch of attorneys have been getting involved to help because, this is just a mess. So
and for the record, not because of Mr. Allen. Mr. Allen in this does not matter. It's the process. If you believe he's guilty or not guilty or anything, have nothing to do with this. This is about the process and nothing else. It's the foundation of the U.S. justice system or the state justice system or how to.
We got one of my mods. He's low T Tilly now. That's no good. Lynn says, "Are you supposed to hire a lawyer if you're facing sanctions?" I mean, it depends. Generally speaking, even attorneys, you're a fool for a client if you represent yourself. Now, that said, like if you get held in contempt, but it's like, Mr. Martin, I'm holding you in contempt right now. Like, I've had that happen once or twice before. Like, sometimes you fuck up a little bit, but you're like in the courtroom that very second. Your Honor, I'd like to apologize to the court. My conduct was out of question for this courtroom. I did not. You could say like I should have certainly thought out better. The judge might say, Judge will be, Mr. Starro, I'll give you a minute to think about how you'd like to address this matter. And you'd be like, look, Judge, I should have exercised more thought. I should have exercised more poise and tact in my decision to speak the words I spoke.
I should have conducted myself in accordance to
you can say it. And my conduct was wholly unfit for conduct here as an attorney. I said not only is it an offense to this court, it's an offense to the state, it's an offense to the defendant, it's offense to the court reporter here, but it's also to everyone here who had to experience that because they come here to have professionals handle their matters. The issue I have wasn't that serious, but I've heard attorneys say that the judge says, and they think about it for a minute, and they might take a break for a minute or two just to give it, like, I think, some theatric. But they come back and say, they'll say, Mr. Starro, upon consideration of your proffer there, we would consider your contempt purged. You may proceed.
Yeah.
So you don't always, but there are going to be times where it's like, I've seen attorneys before where they got held in contempt. I've seen it in person, and they said, Your Honor, I would like to consult with counsel before I proceed further. The judge says, that's fine, because you have that right, especially if it's serious contempt. Like, I'm thinking about putting you in jail. Your Honor, I would like to have counsel present. And the judge will say, okay, great. We'll set this contempt for another day. And until then, this hearing is adjourned, and we'll address these matters later. The other matters, like whatever you were there for. So it happens. It happens.
Yeah. I don't get in lots of trouble, but I'm never in court. So
yeah,
mitigations, negotiations, and stuff like that, and that can be interesting in itself, because
you guys are probably allowed to get a little more fired up there too.
Or extremely stoic, which pisses some party opponents off to no end. When you just sit there and
I bet it does.
Well, the statute of
Do you agree with me? Say something.
19, just sit there.
God damn it, talk to me.
And this is why I love having my channel and streaming and stuff, because I can act out.
Yes,
I really can't.
all the things you want to say. Well, that's the thing too. Like, people wonder, like, do you swear like this when you're in trial? No. I talk like this because I don't get to talk like this in court. Like, there's a reason. This is. This is.
If I acted like this in a negotiation, I wouldn't last long.
Well, if you acted like this in a negotiation, they probably in Sweden they'd be like, Mr. Starro, you realize we have laws against being mean. We have to send you to prison for 6 months.
No,
this is unacceptable. Great. We'll have to put you in jail with Anders Breivik. We have no room for this in Sweden.
Breivik is in Norway, but
I know, but you're such a bad man. You're worse than the doctor who was operating on people for fun.
Oh, the throat doctor. Yeah, that guy. That was interesting.
You are worse than he is, yes.
Yeah. And that was... he might be criminally charged. But they have been trying to get there for 6 or 7 years now.
Yeah, well,
because there are no laws or statutes, so it's a de novo case.
Yeah, but the bigger problem I was reading though is because it's the hospital that awards the Nobel Prize for Medicine.
Yeah,
that they also have been trying to cover it up still.
Yeah.
So.
Yeah.
So
for you who wonders, it's the doctor who replaced throats with plastic tubes and pig throats.
So he was like, and there's a whole I think that's on Paramount. It's called Dr. Death.
Yeah.
It's the second season of it. Basically, he'd roll it around in stem cells and grow like stem cells on them. But then the stem cells would rot on this plastic tube for your trachea. And these people died of like, the one lady had so much medical problems. She had like 150 surgeries, multiple strokes. Like she came in with a, with the little button on her throat, but she could do every other thing in the world. And she left as like an immobilized mess. So this guy was experimenting on people. He had no trials or anything.
Yeah, he is as close as you can get to Dr. Mengele. I mean, pure evil. Bad. Pure evil.
Oh, yeah.
So, and then they found out that he really didn't have the credentials for his position. That was amazing to find out.
Yes. And now we get to the big one. This one, given what's happened so far, I'm not surprised this has happened. But and given how the state has filed its actions against the defense team, this makes a lot of sense.
Yeah. I mean, there's a lot of projection in this.
Yes. So this was filed the day before the Supreme Court's ruling came out. And I know you guys are saying, well, this is from last week. Yes. And like I said, I'm sorry. There's just so much of the Richard Allen stuff. I was trying to figure out what days to do things. I had to get the Kiwi Farm stuff done. I wanted to get the Gina Carano one done. We're catching up to Richard Allen now. So this is in the Carroll County Circuit Court. Motion to dismiss for destroying exculpatory evidence. Now, you could also call this spoliation of evidence, that the evidence the state had, it's no longer there. It's spoiled. It's spoliated. So, and I hate how this is like in the weird, some of these don't like PDF right or OCR right, but yeah, here comes Richard Allen through his counsel, Andrew Baldwin and Bradley Rosie. I'm sure that chaps girl's ass to no end.
She will love this.
To dismiss the charges against the accused for destroying exculpatory evidence in violation of the standards set out in Brady v. Maryland. Now, Brady v. Maryland is one of those landmark cases where if there's exculpatory material, the defense is entitled to it. The state can't withhold it. Now, yes, it took the Supreme Court saying that to make that happen. So, and they talk about Richard Allen stands accused of murdering 2 victims in February 2017. Since receiving discovery, the defense has unearthed significant evidence that third parties named Brad Holder and Patrick Westfall, and we've learned that those guys had made statements before, and other people have made claims that Westfall's like, oh yeah, we did it, or I know who did it. And these are some of the Odinist losers, which, I'm sorry, Nick, I know that's part of your...
No, I agree. These people are diaper Nazis because they're full of shit.
They don't even have to be Nazis. No. It's just, this is a bunch of meth-addled morons. Like, I'm a pagan. I get it. These guys liked r/atheism so much. They're like, I'm going to be a pagan. And I'm sure they share Odin's spear with each other every night.
Yeah.
I got Odin's spear. Come here, brother.
Yeah, I did the mistake of going around okay, I found that person. Okay, who does he know? And down that rabbit hole, and oh my God, what these people need cleansing by fire, because I'm, as a Scandinavian with actual ancestry to Vikings, I'm ashamed knowing that these
simple, you're like these stupid Americans. You can say it.
Can I say
why would it not
Swedish?
be Americans?
Yeah. Why would it not be American? Here's the deal. I spoke to a friend of mine who is an actual believer in that, and he said there cannot be the Aesir in the United States because our gods, as he said, tried to go there, and we were thrown out. There are no Aesir in the United States.
Well, that's the problem. That's the problem here with these guys. And I will say, when that motion came through where it showed the guy's Facebook picture, where the attorneys found it and they put it online in the motion.
Yeah,
I didn't see it yet, but I was like, I have a feeling I know what he looks like. And when I got to his picture, I was not disappointed. It was exactly what I imagined.
Yeah. And here's the thing. Everybody is slightly round.
Yeah.
With a goatee and have caps. But that's 50% of all men in Indiana.
Yeah.
And that's why nobody recognized Richard Allen for years and years. Not one looked at that video, he heard that voice, saw that drawing, and thought, that's Richard Allen.
Yes.
Not one.
Yeah. So we'll go on from here. More facts. The defense would incorporate this into this motion in the contents of a Frank's motion, but the court denied that already because this judge is an asshole. And provides details that supports Brad Holder's and Patrick Westfall's involvement in the murders. In discovery, the defense found a document dated February 17th, 2017, which is only 4 days after the murder of the girls, and the FBI got involved. An FBI report memorializes an interview of Brad Holder. Contained in the document are the words, "The below is an interview summary. It is not intended to be a verbatim account and does not memorialize all statements made during the interview. Communications by the parties in the interview room were electronically recorded. The recording captures the actual words spoken." Also in discovery, 6 days later, after the murders, they interviewed Patrick Westfall. The report itself does not indicate whether the interview was recorded, although the defense would expect that standard procedure would require video and audio recording of all statements. It would, but we're also learning that these cops are fucking morons in this area. So maybe not. Maybe not. After locating this document, the defense sought a copy of the recording and the report so the defense could listen to the exact words of Brad Holder during his interview. That's vital because particularly the statements that the author of the document admits were not memorialized in the document. So yeah, they need to hear it. It's the best evidence. If you have a recording, we need the recording.
Yeah.
Also, the defense requested a copy of all video of Patrick Westfall's interview. That was okay. On September 8th, 2023. So Richard Allen's already been in jail for over a year now, guys.
Yeah.
Because he got arrested almost a year prior to this, and now we're a year and a half later. The prosecutor communicated in a letter. So the prosecutor communicated in a letter that, well, by golly, guys, there's no audio or video interviews of Brad Holder or Patrick Westfall available. The prosecutor offered no explanation of why these didn't exist.
Whoopsie daisy.
Yes. Before the defense had an opportunity to investigate why these material pieces of evidence were not available, Prosecutor McLeland called for the disqualification of Baldwin and Rosie. Yeah, remember that.
Convenient.
Those guys are breaking the rules, Judge. It's heckin' mean. They're really the bad ones. Don't worry about my guys lying and committing perjury. Don't lie about destroyed evidence, Judge. They broke your gag order. They ungagged themselves. It's so mean. It's so mean, Judge. I mean, yes. And then Judge Gull, without a great deal of hesitation, said she was leaning towards granting the request. Ultimately, Judge Gull caused Baldwin and Rosie to be taken off the case. And this is all Judge Gull induced. Her foolishness, her hubris has caused all these problems. These motions were out there. This stuff was out there.
Yeah.
And she didn't bother to rule on it for months and months and months and months. And honestly, Baldwin and Rosie, I will say to their detriment, this is somewhere I am upset at them. I am upset at them for this. The minute he drops that disqualification, I would have said, motherfucker, is this because you guys lost a lot of evidence? I would have put that on the record in front of the judge. I would have made that known, because otherwise, like, I feel like I don't want to challenge them too much because I'm not running that show. I'm not fighting that fight. I'm not in their trench. But it's like you gotta throw that out there right away. Throw the stop sticks out. Like, he's coming at you. Like, stop him. Stop him in his tracks. Because maybe, I mean, to be fair though, Judge Gull will be like, well, I don't care if they lose evidence. They're good boys, I'm sure is what she would say.
Yeah.
So I mean, anything.
Call for a press conference, because you can hold a press conference without disclosing much. It's just that.
Well, that's a gag order issue there, but
we are currently awaiting evidence that the prosecution claims does not exist, but that we have blah blah blah.
You could have leaked it, maybe. Yeah. Which that would have been funny, because then he's going to say, well, we didn't do it. I'm sure Judge Gull will be like, well, shame on you, Mr. Prosecutor. You're a good boy. Sit down. You too.
It was a good faith error.
Yes. Well, no, that's how the prosecutor and the police do it.
Yeah.
We're just simple folk, Your Honor. We done's trying real hard, boss.
Yeah.
It's just
don't
hard.
Mind us.
It's hard being the good guys.
Don't mind us trying to applause here and accidentally hit ourselves in the face. It's only in good faith. I hate the in good faith argument when it comes to the prosecution. There are no good faith with the state.
I agree. Mo says, but she's not reading the memos. To be fair, I bet Mo read those like I used to read like my notebook before a final and when I was an undergrad. I'd show up like 30 minutes before class and go like this. Okay, let's go take the test. Like, I bet she did it like that. So that counts as reading, just not reading well. Yeah, they had freaking warrants for Holder and Westfall's phones, and they never executed them, which that's also a big problem. If you go get a warrant and you don't execute it, that's normally a judge is like, come here. Why didn't you, like, you made me give you a warrant. You should have done something with it.
Yeah.
So yes, these guys have a lot of problems, and a judge who actually cares would be taking a very big interest in what's going on.
I mean, the judge who chatted during the murder trial, that's nowhere close. That isn't close to the misconduct, in my opinion, to what Judge Gull is doing here. It doesn't even come close.
Yes. So this all occurred before Baldwin and Rozzi learned of why the videotaped interviews were missing. Okay, and that might be fair. They say, well, he doesn't have them. That's one thing to say, well, if you don't have it, why don't you have it? And I guess that might be fair why they didn't react. Because like I said, guys, I'm reading this for you, like you, the first time. I think it's more genuine on some of these. So on January 31st, after being reinstated, which once again, I'm sure Judge Gull is just, I'm sure she threw something at her dog and she read that motion getting granted.
Well, she did referenced the findings of the
before it happened.
Yeah, before the written decision was out.
Which don't give her what, like, I read through that, and honey, that doesn't say what you think it says.
Yeah,
you are not one of God's chosen children here. They can still come after you. You are not entitled to. You are not above reproach. The court didn't say that. The prosecution turned the discovery over to the defense, including a letter cataloging the evidence the prosecutor was turning over to the defense. Okay. Contained in paragraph 5, page 5. Words that explain the missing videotaped interview and missing interview if one existed. Due to a DVR program error discovered in September of 2017, all recordings up to February 20th, 2017 were recorded over. There's no detectable audio found on this drive.
I call bullshit. There is no programming error. There's no
Fine work, boys. Yes, I agree. If that should have been sent off to the FBI to forensically retrieve
a
data.
DVR program error,
which means they rewrote over it.
Yeah, and you have you actively have to choose to not take the CD disc out
unless
and replace it.
Unless it was truly broken. But the fact they couldn't figure it out, because here's the funny thing. It's not properly broken because notice it worked. Everything after February 20th, it appears when it says up to February 20th, that must mean everything after February 20th is recorded. So did anything actually break? And I think that shows that is an issue there. Yeah. I did also want to say hi to Valhalla and hi McKinley. How are you guys doing? I see you guys out there.
Yeah, hi. And even if it's broken, the discs should still be there. In evidence.
And they can be examined. Yeah, they should be examined. Now I'm sure what happened is, one of the deputies like, well, I took it home. My son put it in his computer. He done play that Fortnite thingy where he flossing on it. He's doing floss night. You mean Fortnite? Yeah, that's the thing.
And even if it was recorded over with recordings from other cases, doesn't matter. You can send it off to one of these forensic thingies that I know nothing about.
Yeah.
And have an attorney. Okay, this is this case. This is that case. And under the NDA.
Yes. And then they said, remember Holder and Westfall were interviewed during this short window with the days of the murders. The videotaped interviews were deleted by police, and I agree they were deleted.
Yeah.
It is unknown what other interviews were deleted during the relevant time, and that's true. We don't know what they did because they might not, if they didn't make notes or document it, we don't know what they did.
Yeah. And we don't know if it might just not be disclosed yet because the prosecution is a bit ashamed, or because they don't.
Or the cops are still hiding evidence. The cops might still be lying because they've already lied once. They lied about the professor they saw. Who'd you talk to? Oh, we don't remember.
Yeah, sure. And the professor himself. Oh, it was me over here. It was me.
How many?
And the cops just.
Yeah. How many professors did you talk to? Just one. Well, if you know that, which one was it? Well, he was Professor McProfessorson. I don't remember where. Yes. But here's the funny part. The destruction of material evidence of key suspects early in the investigation demonstrates, I'd argue, gross negligence. And if I was Rosie and Baldwin, I'd be saying it demonstrates gross negligence and incompetence every time I could bring it up.
Yeah.
Gross negligence and incompetence. I mean, you want to talk about gross negligence and incompetence, Judge? Here's some gross negligence and incompetence.
This is not
If
a
not
former
intentional
employee
conduct.
sneaking into a room taking pictures.
Yeah.
This is the actual investigators erasing evidence.
Yes. Yes, and it's right. How could law enforcement, while investigating the most serious of its crimes, record over interviews of suspects with recklessness or intentionality? Yeah. As a material part of his defense, I forgot to say, McKinley and Valhalla, if you guys are out there and you want to come on, let me know. Put something in the chat real quick. I'll send you guys a link. Mads is saying, but how would you remedy the destruction of the evidence? Case dismissed. Sorry, case dismissed.
With prejudice. Because
I mean, at some point, Libby and Abby don't get justice.
Yeah.
You know what? You guys should have been double checking. Like, we got these dead kids. Is it recording? Yes, it is. We're backing it up. Double triplicate.
Yeah.
Making extra thumb drives. That's on the state. The state's job is to preserve evidence. If they can't preserve evidence,
and
oh well.
Everybody wants justice for Abby and Libby. But if the prosecution and the investigators fucks up this severely, then it's on them.
Yes.
And not the defense for pointing it out.
And Lynn brings up a point. People were interviewed. How do you know what they said is the same? We don't.
We don't.
We don't know if there's any difference.
Yeah.
So what does that mean?
Yeah.
That's not, we can't confront them. What did you say before? Oh, I said exactly this. Well, I have no way of contesting it.
Yeah. Oh, no worries. I will sign an affidavit. But
that doesn't.
No, means yak squat.
Yeah. And they didn't disclose it till now. Yeah, that is a big problem. So they would have known. They've known for years because the police knew. The police knew
immediately after, probably immediately after. Whoopsie daisy. Hey, boss. I accidentally.
Yes.
Don't mind my Thor's hammer around my neck under my uniform, allegedly. I just happened to erase it.
Yeah. And they point out that part of their defense is going to be third parties were responsible, including Brad Holder and Westfall, because they're part of this Odin's spear. They share Odin's spear amongst themselves. You might call it an elephant walk if you were to look at it in real life, but trust them, bros. It's the Norse. They're carrying Odin's spears.
It's a circle jerk.
Well, but they call it. But they say it's got Norse heritage, so it's all that matters.
Yeah.
They convinced each other. They lied. The evidence will also show that Richard Allen does not know either of these guys, and therefore Allen had nothing to do with the murders. This destroyed evidence, if it ever existed, was expected to contain evidence that could provide exculpatory material to support his defense. If recording of Westfall is never secured, that is too purposeful or a negligent failure to preserve the exculpatory evidence. Yeah.
Yeah. And here's the thing. If a defendant does this, I'm going to erase all my texts in my phone. It's presumed that is because it's against you. But when the prosecution does it?
Yeah. It's not evidence tampering. Nope.
No, it's a good faith error.
Yeah, sorry, guys.
Whoopsie daisy.
Yeah, my bad. So it's just only, experienced defense lawyers fully understand the significance of comparing and contrasting the accuracy and credibility of one's own audio videotape statement with that information which is represented by law enforcement officers in the police reports. It is through this process Richard Allen would have been able to challenge the veracity of statements of Holder and Westfall. However, the state's intentional or negligent destruction deprived the accused of such an opportunity, and that's the thing. Sorry, guys. It sucks. Libby and Abby. We might not know who did it, but that's why it's Richard Allen's rights, not their rights.
Yeah.
The actions have deprived the defense of the ability to compare Brad Holder's words from February 17th to the evidence that was unearthed over the next several years, weeks, and months.
Yeah.
This would have allowed Allen to determine whether Holder's story was consistent with the unknown evidence at the time of his first statement and whether it is consistent with his future testimony, whether it be trial testimony or deposition or statements made to other persons.
Yeah. And if the cops would have bothered to execute the warrants.
Yes.
They could have impeached them then and there. But for some odd reason, speculatively,
Yeah. And they're already saying what I mentioned earlier to Lynn. Without the audio or video evidence, they don't know or will ever be able to know exactly how many inconsistencies existed in their original statement. So you don't know. You don't know what you don't know. We don't know what doesn't exist.
Yeah.
Because Brad Holder and Patrick Westphal will be the ghosts that tell no lies. Is everything you said true? Yes. Have you changed anything? No. Must be true. We can't contradict it. Nor can Allen challenge the credibility of Holder in light of subsequently discovered evidence. Yeah, because we don't know what they said. He can't confront them about their words, and all their testimony is self-serving. On August 30th, 2023, following the depositions in which the state of Indiana and law enforcement learned that the defense believed Brad Holder to be the actor in the murders, law enforcement finally re-interviewed Holder for the first time, is what it believed to be the first time. Are you fucking kidding me?
No.
Following the depositions in which the defense grilled the police, they're like, "Oh fuck, we better go interview." 6 years later.
Yeah.
So maybe he's lying.
Look at the date. August 30th. They learned. September 8th. They mentioned to the defense that whoopsie daisy. We deleted it, but listen, we re-interviewed them a few days ago, so everything's cool now.
This is a fucking joke.
Yeah,
this is a fucking joke. While in 2017, Brad Holder told law enforcement he never met Abby Williams, who was purportedly dating his son. His story changed in 2023 when he talked to law enforcement. In 2023, Holder told the interviewer, "I barely even knew that girl. I met her once."
Yeah.
Therefore, one material and highly relevant contradiction exists. It is therefore plausible that many more contradictions will be available to the defense, but for the negligent or intentional failure.
Yeah. And here's what's going to happen now.
Yes.
Because if they only have this summary, Mr. Holden can say, "Oh, no, that's not right. I said the same thing," and you can't disprove it.
No, you can't. You can't.
No, if it's in the summary, "Oh no, he wrote that down wrong." That's all he needs to say.
Yeah, and he'll say, and the agent who wrote that summary will be like, "The summary is not meant to be exhaustive. It's like if you want the truth, watch the video." Such negligent intentional conduct on the part of police also has resulted in the absence of material which could be exculpatory in nature. And the police have already fucked this up. Like we said, they've lied, they've done stuff. The report stated, though, Holder actually never met Abby himself. You know, and it's all about Richard Allen's rights, and we must place such conduct in a greater and more noteworthy conduct. It's also been discovered that former Rushville officer Todd Click reached out to McClellan in an attempt to bring his attention the existence of an 85-page report summarizing the investigation that went around Holder, Westfall, and the other Odinites. This letter, which landed on his desk May 1st via certified mailing, so there's receipts. Click kept receipts, was not discovered to the defense until 4 months later on September 8th. And only after the defense disclosed in depositions that they were aware of the Odinist ties to the crime scene. So that's the thing. They had to confront those cops like, "We know about the Odinist shit." And they're like, "Oh, okay, I guess, the reports do exist."
Yeah. And
so once again, like, was that intentional, or was it just retarded? I don't know. But it doesn't matter.
It doesn't matter if it's intentional or unintentional, or if they forgot in their circle jerk of morons. It doesn't matter. The fact's still there. Yes. They didn't disclose it.
Yeah.
Still life. It doesn't matter which shape the earth has. We are all seeing each other in Valhalla. Did you freeze, Sean? No.
What? No. Sorry. One of my friends texted. Actually, probably one of my my best friend texted me. One of my two best friends, and he's going through some stuff. So I just wanted to
Yep. Those things have a precedent.
Yeah, it's real life versus the internet, and while I appreciate you guys,
Yeah.
So
work, family, work, farm, YouTube. Yeah.
Yes. So the failure to disclose by the prosecutor rises to the level of an untimely failure to disclose potentially exculpatory evidence. Yes, and this is where Judge Gold wants to get her tampons all steamed up. She should be mad at this too, because a actual ethical judge would be super pissed off about this.
Yeah.
If I could prove it, and I've had situations like this where I pointed out that evidence is being hidden from me, judges generally get very fucking mad about it.
Yeah.
And then furthermore, as explained in the Franks memo, they should say that you fucking got rid of because you're an asshole. It appears as if law enforcement and possibly the prosecutor himself attempted to conceal the identity of the Purdue professor, which contradicted the sworn words of the two troopers and the sheriff on whether the crime scene contained the movement of the Odinist.
Now, I've seen the crime scene photos, and those sticks don't land that way by themselves.
No, they don't.
They don't.
Yeah. And then defense also located a prepared search warrant for the data on Brad Holder's and Patrick Westfall's mobile devices. Each application states that they're a known member of a religious sect, and elements of the murder have potential religious significance.
So they knew this.
Yes, and
within days of the actual murder, they knew this.
Yes, and
they knew this.
This isn't. Guys, I have signed search warrants and helped police draft search warrants. This is fucking killer. These guys are a member of a sect, and we believe the sect has ties to the crime. Hell yeah, we're getting a search warrant. We're getting their goddamn phones. Like I am shocked beyond amazement at Nick McClellan and the cops out there. Like, you guys, I'm surprised you don't choke on the shower every morning, like, and forget to tilt your heads down. You guys are the most corrupt pieces of shit to ever walk the fucking earth. Like, you guys are worse than a corrupt sheriff in the South in the 50s. Like, these guys are a big, and I say this before, if you do this kind of crap, you're a bigger threat to democracy and like the way of life that I enjoy than ISIS will ever be in a million fucking years.
Yeah.
Our
entire structure is based on shit happens, we will survive. But we won't survive when the very fabric is corrupted. And this shit over here, that's the very fabric of our justice system being corrupted.
Yes. And then it didn't. Hold on here. I gotta, each application that known religious sect and murders have a significance. There is no evidence that the warrants were ever served. Also, there's located no discovery regarding the data contained on their phones or electronic devices.
Let's see.
They got warrants and they didn't execute them.
Yeah.
And one of the parties is the dad of the boyfriend of of a murder victim.
Allegedly, white supremacist diaper Nazi Odinists who doesn't like that his son's girlfriend's mother is dating outside of race.
Yeah.
Because nowhere in the history of any country has that led to bad things.
Yeah. Yeah, and it defies logic. Yes, it defies even my logic reading this. That law enforcement would conduct forensic examinations of so many phones in its investigation, yet ignore the phones of Brad Holder and Patrick Westfall, who were viewed as suspects within 3 days of the murders and interviewed by law enforcement. Yeah. Who then prepared search warrants for the phones, and they're like, fuck it.
Yeah, I mean,
these suspicious facts call further to question the circumstances surrounding the destruction of the videotape statements.
Yeah, but here's the issue: this smells, and many judges or Supreme or whatever, they don't care about the smell. They need to see the shit.
Yes.
Then here, the prosecution and the investigators, they've destroyed the shit.
Yes.
There's only the smell left.
Yeah, this is... Oh, God almighty. The defendant requests a hearing at which time he can present evidence. The judge will go, no, I deny it. Your evidence is bad, sir. You're a bad man. And you have bad attorneys. I'm sure she'll say that. The defense files this motion contemporaneous here and with his memorandum in support of this motion. Okay. And this is all memorandum in support of the motion here, guys. This is all memorandum in support. There's a motion up here. This is the motion here. This motion is this top part, and this is what we would call like a memorandum in support. So, you know, and I'm sure it'll be denied.
Yeah.
For reasons cited herein, they move to dismiss all charges. I hope they do.
Yeah. I don't think she will.
Well, of course she's not. Once again, though, with as I stated in the motion to recuse, that signature right there to me is what I call a "fuck you" signature. You're just like "fuck you" as he signs it. Although apparently this might be how Baldwin signs all the time. Maybe he's always saying "fuck you" as he signs a document. Maybe. Yeah, it's like the certificate of service. Fuck you. Here's your service. But no, these guys are fucking saddling up, and I love the fact they're doing this. And I know I talked to the attorney who was working with them on filing stuff, and I said, if you get this, like, if you run into him, tell them there's a lot of people out here pulling for them. They love what they're doing. Yeah. And yeah, I hope these guys are.
Yeah.
Richard Allen is blessed to have attorneys.
Yeah. My only hope here is that he actually survives the trial.
I agree. That's the only concern now too.
Yeah. And for instance, the attorneys that replaced him and then got replaced by his previous attorneys who went through that prison, and everybody thought they were exaggerating when they said he was in a cage and we talked to him through the food hole. Yeah. And then they sent pictures of it. It's an actual cage. It's like 4 feet by 3 feet, which they locked him into to be able to speak to his attorneys.
And then they took pictures of it for the prosecutor, and it's like, that's really cute and convenient. Oh, actually, hold on. We got a super chat here from Let's Go Brandon for $50. I would like to purchase a White Claw, please. Law needs levity. Well, I'm gonna have to go get that. So, Nick, would you mind minding the store for a second for me?
Yeah, sure.
Yeah, and you can. I'm not sure if you're on any trials right this second, but yeah, please feel free to shill your stuff while I'm at it.
Yeah. Well, I'm on the same trial as I have been for the last couple of months, and I will be probably for the rest of the year. The Young Thug Rico trial. That's a hoot in itself. And we are now at trial day 20. I just covered trial day 28. So far, there has been 83 sidebars, and I lost count of the for fuck's sake around day 12. So that's just an unlimited amount of for fuck's sake in that trial. There are 6 defendants. They were 28 to begin with. Some have pled out. Some charges were dropped. And the Young Thug Rico, the district attorney, is Fannie Willis. Now, where have we heard that name before? Well, Fannie Willis is the district attorney for Fulton County, Georgia. She is the district attorney behind the charges against former President Trump. And she is in a lot of trouble. They had a hearing today about Fannie Willis and misconduct within the prosecution's office. Oh, I watched it, and I'm amazed how much the judge allowed Mr. Roman's attorney, Miss Mishkan?
Ashley Merchant.
Merchant, yeah. She got almost everything she asked for.
What did she get? So, what happened today?
She will be allowed. I mean, the judge didn't make much ruling, but as he said...
So this is a pre-hearing...
Pre-hearing, yes.
Okay.
Because she wanted to call 9 witnesses, and everybody, we motion to quash. And
Yes.
the judge calmly explained that, well, the Miss Merchant has made a good faith, blah, 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 here, that testimony needs to be in the hearing for me to conclude, will this matter needs to be impeached or reinforced, but I need to hear it first in open court. So almost everything came in. And then they talked to...
Did all those people get subpoenaed? Because she subpoenaed like 9 people. Yeah. She subpoenaed like all of Fanny's people, her security guy.
Yeah. And And we also found out that Nathan Wade have refused service.
Doesn't work like that.
It doesn't work like that.
Star prosecutors like, I'm not coming. What are you afraid of, bro?
Yeah.
I'm sure the judge is not thrilled about that.
No, the judge says, oh, there are alternative methods for him to receive his subpoena. So he more or less, I mean, sometimes it takes ages to get to that point. And he just, well, I think it's enough what you have actually done, which is certified mail.
Okay.
So yeah, he can consider himself subpoenaed.
He'll have to show back up to court for a hearing, and then he's going to say, "So, Mr. Wade, why were you defying a subpoena to my court?"
Yeah. Now he already advertised he will probably plead the fifth on a bunch of things, but through his attorney. We also found out that whoever is doing the payouts, they get the invoices and they pay out. 2 of those invoices are missing. They are paid, but they are missing in the records. Yeah, that's a huge deal. We are talking about tens of thousands of dollars.
Hundreds of thousands, because with the missing invoices, he's likely made close to $1 million.
Because it's invoice 22 and 25, which coincidentally is the most important ones, where he has 3 months of work.
Yeah, and there's also likely those are the ones that show he's interacting with like Jack Smith, White House counsel, and a lot of DOJ people. So
yeah, so those are missing, and the prosecution's office and the higher.
Oh yeah, he wasn't refusing service on the boat with Fanny.
And because Fanny Willis will probably have to testify, and she has to explain why she lied in church on Martin Luther King Day. That's kind of a big deal.
So she is being forced to testify.
Depending on what the other will testify.
Oh, the other ones say? Okay, well, I have a feeling. And when is this hearing going to be?
Thursday, Friday this week.
Thursday, God, what do I...
Yeah, and I have the Young Thug trial, and I want to cover this as well.
Nick, to be fair, dude, Young Thug will be there when you get back.
Yeah, I know. I can do a Friday evening recap.
Really? Oh, I have stuff that was set for Thursday that got continued. Like,
because his judge said he has set aside the whole Thursday and Friday if needed. So. He was so calm when he explained and everything. And I don't like when judges are too calm. And he was too calm. Now, I like it now because it's going to happen to Fanny Willis and Nathan Wade. But if I were them, I would be shitting bricks now.
Well, I don't think Fanny, because ultimately it's like, what's going to happen to her? Like, nothing's really going to happen to her. So it's like, this isn't too bad for. It's not good, but it's just like it's like Inglourious Basterds. Like, I've been chewed out before. Like, I'll be all right in this one. So I think she's okay.
The main part here is she's going to run for Attorney General. That's why she's doing all these RICO trials, because that's a good foundation for the next level.
Yes, but these RICO trials are absolutely fucking crashing and burning.
Yeah, this Young Thug trial. Mr. Steele, on day 27 and 28, held a master class in cross-examination of the prosecution's main witness.
Which day was this? That was a while ago, right?
No, Wednesday, Thursday, last week.
Oh, okay. So day 27. Oh, we're only at day. Oh, I forgot they had to take a whole month off because the guy got stabbed.
Yeah. And it was no trial day today because one of the defendants got sick. And court is always, I mean, we will be here the rest of the year, at least.
Oh, yeah,
But,
no, that's
his master class in how to cross-examine, I mean, I'm just leaning back and enjoying the show because he's getting evidence in through this witness
Can you
the
send me a
judge
link
previously
to it?
have denied.
Send me a link because I want to watch that because I'm gonna have to. I'm gonna have to watch that at some point. Because I'll need some. I would like, just so I can learn because I do. Like I said, guys, I do watch this stuff and I try to take notes at times. Like if I see good strategies, good tactics, good opening closings, I use those. So
yeah. Now the prosecution made it somewhat easy because they took tweets from this date and shoved it together without context.
Yeah.
To make it look bad. And now Mr. Steele is, but here are the ones in context.
Yes.
And he got the investigators to admit over and over again, I only investigated the material I got from the prosecution.
Mm-hmm. Oh, so it's just the rap lyrics? Or no?
The tweets.
I know that was a contentious issue too recently.
Yeah. No, this is the tweets and Instagrams and stuff like that that they cherry picked.
Okay.
So his investigation, because he's both an expert witness and a fact witness. The Detective Belknap, whatever his name is. But I will find it for you because I'm enjoying myself.
Okay.
And my chat said you are enjoying yourself a bit too much here.
Wow.
Yeah, maybe, but yeah. Let's see here. Fox 5 Atlanta. I'll find it for you.
Okay.
Yeah, Fox 5 Atlanta and Law and Seaward are in the trial, and I choose Fox 5 Atlanta before.
Oh yeah, no. If you can always get around Long Cuck, it's always the way to go.
Yeah. Let's see here. Yeah, here it is. Hold on. And as per usual, you have to scroll up because the judge on day 27 didn't arrive until he was 42 minutes late to the stream, who was postponed 30 minutes. So he was just an hour and 20 minutes late that day.
Well, hey, I mean, when you're never late when you're the judge. So.
Yeah, it's like with magicians. It's in private chat. Yeah. Okay, so that's the Young Thug, and I will be covering it for the rest of the year. Recaps, some live.
You're gonna be able to retire on Young Thug.
Yeah. Well, as long I'm getting quite a decent amount of new subscribers and stuff. So yeah, I on my stream last week, I got more than $3 in ad revenue for that stream.
Oh, nice.
Yeah.
Those are the good ones. Yeah.
Yeah. We are not Mr. Beast, or we are not interior decorators.
There is a new Allen filing here. We can review this one too, real quick.
No, yeah, that's the one they want to postpone the March 18th. Yeah.
Yeah. So here we'll do this. Although I got it through. Yeah.
Hi, Brandon.
Hello, Brandon. Yes, I can see where. Hello, darkness, my old friend. Okay, so oh my gosh, guys. I apologize if this is going to be garbage, but we'll. I mean, it's right here. There you go, Brandon. And I'll save this for the.
And one of the best sounds in the universe.
All right. So there is a new. Oh no, that's for my case. I'm not sure that.
No, things from your own cases.
Court order, so it's not a big deal. But it would show a date and a time. I don't need a fan club. So this is a petition for clarification regarding the contempt hearing. So as the prosecutor's like, I want a contempt hearing. They're so mean. The court set a hearing for March 18th. So the state filed a verified information of contemptuous conduct. The court set that pleading for February 12th, but Baldwin and Rossi got attorneys, and dealing with Judge Gold, that's not a bad idea. Baldwin and Rossi are without sufficient notice as to the details of the allegations or how and why any specific acts are alleged to be contemptuous, and that's fair. The state has referenced the following insufficiencies described as a press release with a gag order without specifying how or why that was contemptuous.
The press release issued prior to the gag order,
which
they claim is contained. It's so stupid.
Yeah. That Mr. Baldwin failed to disclose accidentally misdirected emails, but citing no authority requiring disclosure. Reference to Frank's memorandum as having graphic descriptions and defense created demonstrative exhibits, but again failed to advise how that's contemptuous. Yeah. A graphic description. Well, we're trying to explain stuff. Your Honor, they're talking about how bad it was.
And I can bet good money in trial the prosecution will show the actual pictures. Like, I mean, graphic.
Your Honor, he's talking about the girls being murdered. It's like, well, they were murdered.
Yeah.
Referencing Mr. Westerman's unauthorized photographing of Discovery, but failed to allege that was a fault of Baldwin and Rosie, and how it was willful conduct. And then Mr. Baldwin brainstorming with Westerman, violating both. And I got it as images. Orders, but ignore that an in-chambers meeting brainstorming and strategizing with persons not on the defense team was declared permissible. And then finally, alleging a trend of Baldwin and Rosie not being completely honest, yet offering no details to cite any authority or requirement to support that allegation. Gosh, I guess you know who wasn't completely honest about things lately? I mean, there's somebody that wasn't completely honest. I mean, I could say their name.
Who was it? State
of Indiana.
Yeah, State of Indiana.
It seems clear the state is really attempting to charge indirect criminal contempt. See the motion for denial of this. As such, a separate hearing would be required. That's fair. Okay. And then number 6. Attorneys Baldwin and Rossi respectfully request notice that whether the March 18th hearing will be a formal advisement of the specific allegations or whether the court anticipates hearing testimony, receiving evidence. Okay, I think I know what they just did there. I think I know what that was. Is this their way of saying, Your Honor, are you going to fuck us again like you did the last time? Or is this going to be, are we going to get notice at this hearing?
Yeah.
Or is this the actual, like, we pull off our pants and, like, it's time to have sex hearing? Like, which one is it?
We are not prepared to have this in chambers this time.
Yes, we did this once before, so which one is this like?
Yeah.
God, so David Hennessy, you are a fucking mad lad. That is beautiful.
Yeah. Respectfully submitted. Yeah, sure.
that is beautiful.
Yeah. In lawyer speak, when you add on respectfully,
I respectfully submitted on all my motions.
Okay.
But that ending part was just great. That was Are you gonna do what you guys did the last time? Well, it's like you fuckers. It's like you son of a bitch.
Yeah, the prosecution coming in with knickers in a twist and everything, and
yeah. That is brilliant work.
Yeah.
It's funny when you get to do shit like that. So.
And it's all out in the open.
Yeah.
Because what else can the judge do?
Yes.
Yeah, she can do everything again. And up again to the Supreme Court, who will...
Oh, yeah, if she does it all again, they're going to... Well, it won't go to the Supreme Court again. At that point, if she tries to remove him, yes, it would probably come back. And the Supreme Court would say, look, we already did this. But any of this stuff, they would have to appeal. And if it came to the Supreme Court, they'd probably say, this is stupid. But they're going to force that to go the normal route. So, also, Nick, one more time, I have to, because Brandon did this, and it's got to be, we got to do this here.
Okay.
Just like I got to do the PPP thing.
Yep.
No.
All right.
$100. Wow. From Medicare Masochist, also known as Let's Go Brandon. Guys, Sean isn't that gay. He just drinks like the baby boy that he is. How'd you found me out, bro. You found me out. It's like, shh. What's that?
Yeah. And speaking about drinking, on Friday, I will review Zachariah Anderson's first interview. At that time, the only charge was stalking. And I'm going to review that. And by popular demand or unpopular demand, the Wheel of Regret will will join me.
Is the Wheel of Regret? Is the Wheel of Regret outside? It's like from Conan. Nail him to the tree of woe.
Yeah. And in the Wheel of Regret, it's hot sauces, it's horseradish, it's different kind of alcohols. So once we reach a certain level, I will spin the wheel and do what's on the wheel. And it's called Wheel of Regrets for a reason.
Well, Kelt, this is a good question. I'll answer this before I come back. She can kick him off again, but remember, she has to show why there's no other option.
Yeah.
And they point out in the opinion, all these other options could have accomplished it. In fact, some of her options already accomplished the task. So she's mad at them for violating a gag order, but she put a gag order in place. Like, she's remediated issues, and then she's bringing them back up again as further reasons to punish them, like doubly punishing them. So no, I think Gull has been put on notice. This is not enough.
Yeah.
So
you need to put things on the record.
Well, it's not only that, but just what you said is not going to work.
Yeah.
Like, the Supreme Court looked at her and be like, honey, listen, honey, this ain't cutting it, honey.
But then again, she can do it all in one hearing. I'll find you in contempt for that, and then for that, and then for that, and now you're out again.
I think she loses if she does that.
I don't think she cares.
Well, yeah, but then if she does it again, she's getting thumped, and that's it. So,
yeah.
Give me the PayPal link before Brandon's saying, give me a PayPal link before the Chinese claim me. Do I have PayPal? Hold on.
I think that's directed for me because he is threatening to buy all the slots in my Wheel of Regret.
Oh, okay.
Yeah.
So yes, Brandon for $10. So, Nick, while you're handling that, I'll be right back because I have to go get some more White Claw material because I figured out how to make my own White Claws and they're 100 times better. They don't have that malty taste on the end of them. So
I wouldn't know. I've never had one.
You'd enjoy it. You'd enjoy it.
Probably. Oh, I bought mead for Friday.
You bought mead? I was gonna say, you guys make mead up there on your own. Like I've had mead is real good.
Yeah,
it sneaks up on you.
Yeah, I mean, you have this bottle, and it's quite it costs like $8 or $9 for a standard bottle, but it's like 13. It says 13% on the bottle, but it kind of still produces alcohol after it's bottled, so it could be anything in it. So that will be interesting. And I know the recipe, and I probably could make my own mead, but I can't be bothered.
Well, when I years ago, I had a friend through my wife at the time. He made mead. And I was like, I drank it, and I was watching. I was watching a Formula One race. And I was drinking it, and I started drinking at the beginning of the race. I'm like, "Oh, this is good." And I just I don't remember the second half of the race. It caught up pretty quickly. So
yeah. Oh, I had that happen to me in my old favorite bar, who is now closed, sadly. The bartender there liked to buy in beers of different kinds, and I tested them out and gave my review on occasions. And then he gave me one, and this was good. I'll have another one. And then I had another one. And then I had another one. And he kind of looked at me funny. And then I tried to go to the bathroom. That was an experience. And then I looked at, once everything was done, looked at bottle. 16%. It was Belgium monastery beer or some Trappist beer or something like that.
Oh,
all right. That was an early evening.
So who's McKinley is sniping? Oh, that's fine.
Yeah.
It's okay getting sniped.
Hi, McKinley.
Hi, McKinley. But anyways, I'll be right back, Nick. So give me 1 second here.
Yeah. All right. Yeah.
You offered to send me some of my mead, but you ignored my comment. I'll talk to you, Stabby. I'll talk about your mead. But anyways, your precious fluids. I'll be right back.
Yeah. Fun fact about McKinley: she is almost 2 feet shorter than I am. Yeah. What else do I have to talk about? What else do I have planning going forward? Well, of course, I will probably do my own Delphi stream sometime in the future when I get the chance of it. I have my Serial Killer Saturdays. I'm currently doing the Eileen Warnes trial from 1993. 1992, sorry. And the interesting about that is it's Florida, of course. She is the first convicted female serial killer. And Mr. Gosney's mentor is the one prosecuting that case. So Steve Gosney has on occasion joined me on those streams. I never know when. I send him the link, and if he has the opportunity, he will join. But that's the most amazing thing about that case, that trial. It's so clean. The judge has complete control of the courtroom. The prosecution and the defense, they respect each other. They don't do sneaky things in front of the jury. There's objection. And then after, and everything stops, the judge says, okay, foundation for the objection. It's so clean. You never see this in today's trial. It's so clean. And other thing, Steve Gosney said that prosecutor, who was his mentor, was a bear hunter and once had to almost wrestle a bear. So yeah, that's an amazing case to follow just because it's so clean. I mean, cases in the 90s were so clean. And then something happened after the new millennium as things started going O.J. Simpson again, with prosecutors doing shady things, cops doing shady things. I mean, after O.J., when was that? 91?
90? Well, O.J.'s trial was like 94.
Okay.
Yeah.
Okay, yeah. But
I'm not going to tell you how old I was in 1994.
I was an adult when the Berlin Wall came down, so
I don't want to. Then I definitely don't want to tell you how old I was when the Berlin Wall fell.
Yeah, that's one of the most something I realized later on. I went to school with kids to active World War II Nazis. Yeah, that was an interesting realization. And
I didn't have that, but I'll say it like this, then that way I don't make you feel bad. When I saw the Gulf War as a kid, I thought I was in Greenland because everything was green on TV. So But yeah, guys, that is it for Richard Allen. We're all caught up on all the fuckery, and it's not set till April. Sean, send a link. Sean, send the link. Sean, to join the stream on StreamYard. Sean, yes, I did send the link. I sent her the link. She should have it by now.
Yeah.
Yes, apparently she's going to stream snipe you.
Yeah.
So,
well, she's with us in spirit because she's stream sniping us.
It. Yeah, but I appreciate the $10 or the $12 super chat, not just $10, $12.
Oh,
and also, what time on March 18th? Because I don't know if this hearing is going to be televised. Although I have the feeling like when you're like, oh, I'm going to make time for these, they turn out to be wet like mouse fart conventions. Oh, actually, if it's in the morning, I can do it. Maybe.
Okay, goalie 171 didn't understand me. Well, without disclosing age, I was an adult when the Berlin Wall came down, and
so he was north of 18.
Yeah. So, and I went to school with the kids of active World War II Nazis, and that would explain a lot. why I went into so many fights, because my dad taught me principles. Without
like,
becoming...
you guys didn't fight hard. Well, the principles, Nick's like, you fuckers, your dad didn't fight hard enough. Why this? Yeah, Nick comes in there. It's like, in my house, we never surrender.
Yeah, when we walked.
Yes. Carl Gustav never would have surrendered. He would have kept fighting. He didn't go in the bunker.
And then Charles XII, who went to Turkey and brought back meatballs.
Yes. Well, that's well. Isn't he technically Carl Gustav, or is he technically Charles? I thought it was Charles.
No, Charles XII. And
okay.
we have our current king is Charles the 16th, Gustav the 8th, or something like that.
Okay.
Yeah.
Because I was at the one Carolus Rex. Okay, there, I'll use that.
Yeah.
Okay.
Yeah, Carolus Rex was the warrior king, or so that was about that. And he was an excellent strategist, but he kind of tried to fight on too many fronts. That song is a good song. That entire Sabaton album is a good album.
We reloaded, so we're good. I reloaded up. Good for you. I did want to mention tonight, guys, I will be on Locals at 8 o'clock, or 8:30, not 8 o'clock. Jeez, not too early. Over at potentiallycriminal.locals.com. I don't know. We're going to be talking about hanging out. A lot's been going on in the world. So a lot of stuff in the world that doesn't necessarily fit these streams. If you guys want to be a member for free, you can join for free. But to be in the streams, you need to be a supporter. So that's $3 a month. Or you can do a 1 month free with the promo code Criminal 2024.
Yeah. Oh, I need to at least give it to Ian or somebody with guns. Swedish Supreme Court, with a couple of months ago, decided on an appeal or something like that. AR-15 is approved as hunting rifles in Sweden.
Could I see that? That'd be a fun one to cover.
Yeah, I'm trying to find, because it's just paper, but I will try to find it.
It's not.
It was reported in the news, and I was saying, what now?
Oh, you're
Sweden?
Like, in the paper,
socialist paradise?
You send the paper, it's like, they nailed it to a tree. They nailed it to the trees
right
out in the
middle.
There. They wrote it to Galavere, and they nailed it out in front of the ore mines.
Yeah, they threw the runes down to the sand and made a decision.
Yeah.
No, I will find it, and if I can, I will have it translated and send it over.
Old Line Red said, my law school was bookended by OJ in 95 and Clinton 98. It was awesome. Not really. Yeah, that would be yeah. Yes. And then the name of some sort says the spirit of Eugene Stoner spreads far and wide. Yes, it does. Trenton says, did I see how Andrew ranked me this morning for... Yes, he did. And I'm glad I got S class. I'm glad I was S tier.
Oh, did I make it this year?
Well, no, he was ranking people who did the Gina Carano coverage.
Okay. So not the overall rankings. Okay.
Yeah, no, not overall rankings. I won't qualify for that. I'll be in like...
Yeah.
I'll be in like, I don't know, like it's I remember reading from I read this book this Navy SEAL wrote about his when he was in his training, and one of the chiefs yelled at him, you're at the bottom of this class. He's like, you're whale shit. You're at the bottom of the ocean. And I'm like, that's probably where my streaming, I think, is. It's lower than whale shit, and that's at the bottom of the ocean.
Yeah, we are the worst team, and you're the worst player on that team.
Yes.
Yeah.
So are you gonna bite us? Are you gonna send us Swedish AR variants now? I want you to send me AK-5 variants.
Oh, the AK-5.
Or you can send
what an amazing weapon. I had this in Army duty. Such an amazing rifle.
I just want the spur mounts for the G3.
Now, I can't...
Well,
with all the hunting licenses and everything around that, I have to... I mean, the applications... Sweden is not a democracy. We are a bureaucracy. We're a nanny state. Yes, you can have it, but here's kaplonk the paperwork for it. And I have to be a member of a shooting club. I have to do the shooting test and the theoretical test. I have to prove to them I'm not insane and all of that. And I can't be bothered. You're muted.
He's saying, when would I do a crossover stream with Scott over in Calibrated? I don't know. That dude's big time. I don't know if he'd have the time to want to talk to me. So I'd be fun, though, I think. A lot of those guys would be fun to talk to. Carrie actually has a question for you, Nick. Does Sweden have a right to bear arms in your documents? And I'd argue probably not, because that would be... Yeah.
If we don't...
Yeah. Oh, no.
If we... hunting, we have to have it secured on the way there and on the way back. We can only bear it at the hunting station and the shooting range and as a sports shooter. Once it's in our home, we have to have the rifle, the pin, and the ammo separated in a secure, safe stuff.
Yes.
And it's really because we don't have that self-defense thingy much. We had a case
that's what grenades are for in Sweden.
Yeah. We had a case about a decade ago. A man the local teenage gang harassed them non-stop, and then they broke into his house. So he got his shotgun, shot one, the other one turned around and fled, and he shot that too.
Well, that one's probably the bad one.
Yeah, but he was convicted for both.
Well,
but it was appealed. It went up to the Supreme Court. So first, self-defense. Second, no.
Yeah, well, that's what I was gonna say. The second one's probably not good, but they'd be like, "Yes, you shot the first guy. Yes, we agree." And then they're like,
"Yeah." He claimed he thought he was running back to the car to get guns. So preemptive self-defense.
There's probably a good chance that was happening.
Probably, yeah.
Yeah, I mean, he was probably right. So,
Yeah, and I still haven't seen Ian's that report about the 5.56 ammo being, it's done for lethality and stuff like that. And
that guy he covered today.
Yeah.
Yeah, well, that guy's a known shill, so
yeah,
there's no reports on it.
Yeah, I mean, 5.56 is the ammo for the AK-5, and in the Swedish Army had that principle.
Do you need more time? You look like you're not ready.
Yeah, AK-5 and the 5.56 ammo is designed to injure, because an injured enemy soldier takes up way much more resources than a dead one.
But ultimately, it's meant to. I mean, they made it so it would go through body armor, so it's also just meant to, it's meant to kill, so it works. That's all. That goes along with that goes along with you shoot them in the head, they'll come out their foot.
I love to shoot that gun. Such an amazing gun.
If I lived a little further east on the edges of Cleveland, I'd just walk out my front door and shoot it. But I don't live in Cleveland, so I can't.
That's one of the reasons why I'm still considering retire in the United States. Problem is, I lose my government pension if I retire outside of the European Union.
Can you just not tell them?
No, we live in a bureaucracy. Everything I do, I have to report. I'm moving over here. Okay, you have to report it.
Well,
I'm moving over there.
There aren't ways to scam that. There's got to be a way.
Yeah, sure. I mean, I need to be 6 months and 1 day, have a permanent residence in Sweden.
Well, there you go. You can six non-continuous, 6 continuous months or non-continuous months.
6 6 contagious months.
just hang out and come back. You can do that.
Yeah. Oh yeah. I'm going to Matsuri this year, by the way.
Oh, okay.
Yeah. In Houston in August, and that's close to McKinley.
That is.
You have you ever been to Houston or in a similar climate in August, Nick?
Not in August. I've been to Houston in April.
Oh, it's so much different.
Yeah.
Have you ever been have you ever been to Florida when it's humid out?
Nope.
Okay.
I've been to Texas, and then I had a fly through New York. That's about it in the United States.
You're gonna want to.
I've been to Tunisia, but that's not humid, at
heat.
least.
Yeah.
That's dry heat. You can dress against dry heat. I've been to Ukraine and Russia. That doesn't count because it's more or less the same weather as here in the summer, at least.
You're gonna want to drink a lot of water.
I found out in Texas, in Houston in April, why Americans like Bud.
Air conditioning.
Because you want beer, but you don't want beer with a lot of taste.
Yes. Well, you're also going to understand why we like air conditioning too.
Oh, we found that out because we had one very warm day where we went from the hotel to the rental, and I was more or less soaked. Well, I mean, 20 odds.
That's what's going to happen in Anime Matsuri. But you know, the good thing is when you go to Matsuri, you're going to be at a con, and you're going to be a sweaty guy wearing a beard. And you know how many sweaty guys wearing a beard are that are at anime conventions? All of them. Yeah. So you're gonna be set.
Yeah.
Now here's the other problem though, because like if you want to meet up with people, you can't say, "Hey, look for the sweaty guy with a beard."
Yeah. Now look for the 6'4" guy with a beard. That might
help a little bit, but it's gonna be like little kids at the store. Are you my mom? Are you my mom?
And then I need to find a hotel that is close enough for me to just go over. Yeah, I mean, I can't be at the other side of the town and try to get there. I need to be close and everything. And the airfare, I applied for I don't need a visa, but I still have to apply for something. Yeah.
Wow.
So it's a lot of crap going on. Yeah. But yeah.
Oh, well, looking forward to it. That'll be fun for you. Welcome to welcome to Burgerland again.
Oh, the absolute best ribs I've had in my life I had in Houston.
Yes. Well, that too, but yes, welcome to Burgerland. That this it's like Idiocracy. Welcome to Costco. I love you.
Now, I went there in 1996, so this was pre the big plane in towers thingy.
Yes.
So it was actually quite easy to get to the United States.
Yes.
Since then, it's much harder. I have to affirm I'm not a terrorist. I have to affirm a lot of stuff by crossing in a paper, and then I need to be cavity searched at the customs or something.
When you show up, you need to take your bag, and before you come, rub a dog biscuit all over it. The dogs here in America love that, and like that, it'll be really fun because then you get to it's a lot of fun.
I might overplay my bad knees and use a wheelchair so I can skip ahead everything.
Oh yeah, instead of the wheelchair, you can ride on the little carts they'll take you around on.
Yeah.
Yeah, that is a way to do it. I recommend that.
Are you doing okay, McKinley?
Sorry, I'm not tall enough.
Okay.
Well, yeah, I told the chat I'm almost 2 feet taller than you. So we found that out a few streams ago because I'm almost a foot taller than Dave, and Dave is almost a foot taller than McKinley.
That's true. This is true.
Oh, so McKinley, I don't know if people don't know you. Would you like to say hi and introduce yourself a little bit?
Hi.
Run your
My
channel.
name's McKinley, and I have a YouTube channel that I don't ever do anything on, and it's called Legally Live.
You're trying to change that.
Yeah, I'm gonna change that. But lately, the last thing I did was I stream sniped Legal Vices, and it was a lot of fun. Before it turned into drunk political talk, which, nobody needs that.
Yeah.
So that's it.
Okay. Oh, so Tilly wants me to show you scientifically accurate Barney. So,
okay.
Oh, somebody's hacking. I can hear him hacking.
It's me.
No, I know. I'm just. getting your hacks into the. Hold on here.
Yeah, I just saw that. Oh,
4,
Sweden
5
is a
and 3
shithole.
quarters.
And yeah, I kind of agree. It's a nanny state. It's a bureaucracy. But when I've been here for many years. I mean, I'm used to it. That's why I live rural with my farm, and
that's why he lives out in the woods, writing his own political diatribes.
Yeah, me and my moose.
Are you a big math guy, Nick? Like
No,
math?
no.
Oh, okay. Sorry.
No. I have a law degree. I don't do math.
Okay, well, I didn't. You could have been like the humble mathematician.
Hi, Jim.
Hi, Jim. Valhalla.
I didn't even remember that you said anything, so you're good.
So one of the people really wanted you to see this, so we're going to turn it down a hair. But this is scientifically accurate, Barney. This is for you, McKinley.
Scientifically accurate, Barney the dinosaur. He's a T-Rex and ripping flesh is what his arms were used for. Barney had a septic bite, evolutionarily perfected. If you got away until a bite, the bite would get infected. Seriously, kids, get out of there. The hunters are trying to drug him. Why the hell's he in a house and why are you trying to hug him? I hope the state takes you away from your irresponsible parents. Barney's jaws were like a vice, crushing 5,000 pounds per square inch. All I hear are children's screams I'll never forget. Blood curdling cries as they're torn in half, learning the alphabet. 40 feet long, 20 feet high, this seems so insane. Some maniac said, put him in clothes and let him drive a freight train. Barney would eat his best friends, baby Buck Gianna Rip. He'd tear them into tiny shreds if he was scientifically accurate.
So, yeah, there you go. That was for you.
Oh, that is evil.
Yeah.
I really want to show that to my child, but she already claims that she can't sleep in her own bed because of T-Rex. So.
Well, that's a shame because my lawyer friend minored in math. He's like an alien. Yeah. Like the lawyers who have STEM degrees, those guys are weird. You know, they got like electrical engineering degrees, anything like that. Yeah. Those are weird attorneys.
I saw that family court judge woman on, and she more or less calculates, well, you earn this and you earn that, and that means the alimony comes up to this. And I'm sitting there, huh?
Yeah.
Oh.
Yes, Alpha Fox saying, Nick, how do you feel about the Industrial Revolution?
Is that a pun of me being in labor law or something?
No. That is about you living out in the woods and being Ted Kaczynski.
I'm doing good out here, and if you hear any banging noises, I have nothing in my cellar.
Oh. Alex says, why the fuck would you have an engineering degree and a law degree?
I mean, why?
You would go into labor law. Or I mean, not labor law. You would go into patent law.
Patent law, yeah.
Because you need it. You need hard sciences for those. So you need a degree in like engineering, chemistry, physics, something like that.
Yeah, you need to look at the things they send in and say, sure, and rubber stamp it, or no, and rubber stamp it.
Yes. So, yeah, we were just finishing up all the Richard Allen stuff. Did you have any thought on all that?
Yeah, no, that's crazy. But what I didn't hear, like at the very end, I heard something about you saying that they said like it seems like she's trying to hold them in contempt or something.
Mm-hmm.
Is she trying to hold them in contempt?
I mean, I think she wants to. She wants to.
Yeah, but she's kind of tied by the Supreme Court decision now, so she has to do it by the books.
Well, even if she does it by the books, what they've said is the Supreme Court kind of made it sound like what they've done really wasn't that bad.
Yeah.
And there's other ways for her to fix it. So I think she's going to hammer them the best she can, but, you know, she's still going to not get her way. So.
Yeah. And then once in trial, everything is up to the judge's discretion, and she will sustain.
Yeah, well, I mean, if she holds them in contempt first, though, like that's going to be a giant pain in the ass.
Well, she's got a lot of problems, I think, ultimately. So, I think, I don't know. It's going to resolve itself, and it'll be without Judge Golder ultimately at the end of the day. Like that's my prediction. Ultimately, Judge Gold does not see this go to trial.
Yeah, I don't think so.
That will be. Yeah.
I
can't wait for Judge Gold to try to send me a contempt motion. I don't appreciate you making fun of me, Mr. Martin. and then I would go on to Rumble because I can do it on Rumble, and I would wipe my ass with it on live stream.
Oh yeah,
I'm over here in Sweden, and she can't do shit about it.
Well, yeah, she can't there, but she can't do shit to me here either. But I would love to see something from her. Yes,
I want my name named.
Yeah, throw a slice of bread at her.
Yeah, I want my name in some of her. Oh, these are blah blah blah. You are conspiring with these international streamers, produce gag order or something. I don't know.
That'd be great. Yes, it would.
I would grief the living fuck out of that one.
Yes, wanted by the state of Indiana.
Yeah.
And that's cool because they go to Interpol. It's like, we want a red notice on this guy, and
did it.
And they'll be like, wait, what did she do? What did this Nick guy do? And Indiana's gonna tell, like, he made fun of a judge, and they're like, what?
We would roll out the red carpet for him.
Yeah. So,
have you ever been held in contempt?
Me? I've had the judge say, like, Mr. Martin, you should really. I'm going to give you a minute to kind of figure out a way out of this real quick. So not really. I've been warned. And I was cruising for a bruising, but no, I've never officially been held in contempt. I've always been able to. I got over my skis one time really bad, but I learned my lesson. And I met with the judge afterwards, and I really apologized to them, and they appreciated that, but they're like, yeah, don't ever do that again. Have you?
No, but I ran against a judge who held my friend in contempt.
Oh.
I was pissed. But he had to actually do jail time, like 70-something days, I think.
For what the fuck did he do?
He said during voir dire, she told him not to, like, ask the jury a certain question, and they were arguing about it up at the bench, and he said loudly, I'm trying to show these people how hard it is to get a fair trial in your court.
Oh.
And she gave him 70 days?
Yep. Well,
or was that 70 days of him refusing to apologize?
No, he didn't go straight into custody. She didn't make the ruling right there. It ended up going to another judge to make the act, to sentence him. And they sentenced him to 90 days, I think, or maybe it was 180.
Yeah.
But he ended up staying in day for day, 70 something.
He did 70 days in there?
He was in solitary the whole time.
Well, yeah, because they want to protect him. And also punish him probably a little too. But.
They were punishing him.
Yeah. The courts in Texas didn't get involved? Well, that's a bit much.
No.
Oh, because here in Ohio, they would have been like, listen, Judge McKinley, I get you're mad, but we're not doing 70 days in jail on this guy. And you'd have been like, yes, I am. And they'd been like, no, you're not. But I can't believe that. So did he get a lot of street cred out of that?
No.
Oh.
No, it was it was a pretty crazy situation. It was his second time to be held in contempt. So, the first time it was because he did, he was standing at the bench and he did this motion.
Mm-hmm. Well, to
the prosecutor, and somebody told the judge.
Well, that's going to get you.
Yeah. I mean, he said he was just rolling dice at the hip, but.
Well, Yeah, I'm just gonna say, bro, that's come on, bro.
No, that one was an obscene gesture for sure.
Yeah, that's barely something you can get away with
Did you give
in
him commissary
negotiations.
funds?
Huh?
Did you give him commissary while he was in jail?
Yeah.
You did? Okay, good. Well, that means you're a good
Yeah,
friend.
yeah, and I would go visit him all the time. Because you could meet with lawyers, like, there was no.
Yeah, you can meet with lawyers
I didn't have any
anytime as much
time.
as you want.
Yeah, like in the
And
middle of
there's
the
no
night,
time limit.
whenever.
Yeah. Did you bring in like we're gonna play games for a minute? We're gonna play like Candyland or something.
Yeah, right. I wish.
We're gonna
That
play
would've been way
Connect
more
Four.
fun. Yeah, no, it was crazy.
Mm.
But I've never been held in contempt. I have been. Oh yeah, I'm not gonna chug a beer. You're right.
Oh. So did that kind of like how bad did that fuck up his practice? I mean, 70 days probably pretty much totaled it. I mean, he probably got back on his feet, but that had to be a big problem.
Yeah, he had a lot of attorneys that just like helped him out with everything. So
Okay.
it
So
wasn't
people
a
were there to have his
problem.
back. Okay.
Yeah,
good.
there were attorneys that had his back. Plus, he had a guy that worked for him, so
that
was fine. But
Okay.
then the guy started his own practice, like as soon as
He got
the guy
out.
that was in jail got out. So yeah, so I
Hmm.
don't really know. I haven't talked to him in a long time because then the pandemic happened, and
Oh, okay. Yeah, so Brandon says for $10, well, Judge Kinsley, well, there's no Judge Kinsley, but Judge McKinley, you won't chug a beer.
He's right. I don't even know how to shotgun.
You don't?
No, and I don't want to know either. I mean, like I've seen it, but I'm not trying to learn.
Are you from Texas?
Yes.
You're a child of the Yellow Rose, and you don't know how to shotgun a beer.
Yes. I mean, I think you just like jab a hole in it, and then.
Well, there's jabbing a hole, but there's a bit of thought you do into that. So.
Do you have to open it first?
No, because it's sideways when you're holding it. Like this is empty. So. No. So the way you do it, normally you take like. You can use car keys, but like I normally use like a pocket knife. You come up and you stab it, but you normally cover it up because there's carbonation in it.
Yeah.
So you got to hear at the bottom. You would then pull it upright, and then you would, open it up, and then.
Okay, so you do open it.
Yeah, but not till it's upright. If you do it sideways,
Yeah,
nope.
That ruins a decent thing.
Yeah, well, you think it's bad. I tried to shotgun a White Claw once. That was awful.
Oh, God. Yeah. All I have right now is
so much carbonation. I looked like a girl in her first porn shoot ever.
Yeah. No.
Dry. It's dry cider, but it's wet.
I know, right?
Mm-hmm. So.
Ooh, you have tattoos?
Yeah.
I didn't know that.
Yeah. I was an adult in the 90s, and let's leave it at that. And everybody knows what I have on between my shoulder blades.
Got all the tribal tattoos. You have to keep up. Do you have Ace of Base tattooed across your shoulder blades?
I do not have an Ace of Base tattoo.
You're national heroes. I'm sure in the 90s, you're like #1 band in all of Sweden.
Yeah, they were. And then they found out that one of the guys were an active Nazi, and they kind of fell through.
Oh, is that what happened to him?
Yeah.
Well, he was he was active in Nazi groups and they got rid of it?
Yeah, they got a hold of, he were, and then he started the band, and then they found out. And when they tried to have him say, "Oh, that youth, I have nothing to do with that anymore," he just said no comment or something like that. And,
oh no. Okay. Yeah.
I do not have Ace of Base tattooed on my junk.
That shame says, who hasn't beer bong box Merlot before?
I have not.
That. I have not done that, but I've done a Tour de Franzia before.
What's that?
So Franzia is a company, they sell box wine. So it's like a Tour de France. It's like it's a drinking marathon, It's like a drinking race with the box wine.
Ugh.
So you can do
Like
drinking
Power
games,
Hour?
kind of like a case race, yeah. And oh god, it's rough.
Oh, I hate throwing up wine. It's so gross.
Yeah.
Yeah, I'm not a wine. I'm a beer and spirits guy.
Yes, too bad he could have just said he's part of the Ukrainian military. They'd have been like,
oh, yeah, the good old Azor.
yes.
What?
Brandon says, I didn't puke when I shotgunned the White Claw. I did not puke. I kept it all down. That was rough. But it was. I got it done. Brandon, you even admitted you had problems trying to do the White Claw. But I got it done.
Ugh, you did?
Yeah.
That's so gross.
Yeah, it made a mess everywhere, but yes, I did it. Oh, I'm not going to stop.
Ugh. I would definitely stop.
Oh, no, you can't. You got to take it. Yes, you got to be like Vince McMahon. Take it. Yes. More. Yeah, you can't back down. Bella says, do you have to let people use your bathroom in Sweden? Well, I'm assuming you don't want them peeing on your floor.
It's I have a big bladder. I mean, I've been drinking since I was 12. Who do you think I am?
Yeah.
I mean, oh, do you have to let people use your bathroom in Sweden? Normally, we just announce it and then we go. We give out a lot of information. Not only I'm going to the bathroom, we often tell you what we're going to do in the bathroom.
Ah.
Mm.
So you're like, I'm going to do cocaine in the bathroom. I'll be right back.
No, I'm not a politician. Okay, Brandon. Brandon, I will send you on Twitter DM. Hold on.
Yeah. Oh, he's gonna. Oh, you have his Twitter. Okay, good.
Well, one in the Brandon Collective Twitter I have.
Ah.
He has more than one.
According to Jeff, Let's Go Brandon is a
if
collective.
Your ship doesn't, you have to have more than one Twitter. I've got multiple Twitters.
I have two, but that's because I forgot the password. And
I have
my oldest Twitter account. That email is I had it on a server that no longer exists, so I can't retrieve it. That was fun.
Okay, well, guys, I know McKinley, you just got on, but I am going to get ready for my local show starting at 8:30. So I don't mean to cut it short.
I just wanted to come on and say hi.
Yeah. Coming on. I appreciate you being here.
I was determined to get that link today.
Oh, well, there you got it. Hey, if you
Thank
want to,
you.
just let me know. How many accounts of mine have been banned? Well, I got a bunch of them banned back when you didn't need like burner phones. It's just a bunch of internet accounts that got trashed. So a bunch of throwaway Google accounts. But the good ones I've got. I still have my OG ones. That's the important part. So.
Yeah. I have everything on more or less 3 different emails, and then I have my work, which is through. I got it set up for me.
So Bella's saying that she was told when she was young that in Sweden, if I walk up to your door and knock on it and say I need to use your bathroom, you have to let me use your bathroom. Is that true?
That I haven't heard of that. That's more or less we are polite, maybe, so we let you use it, and that is why we nowadays have so many elderly robberies.
And then Stabby says my one and only Twitter account got banned when Keemstar retweeted a tranny joke. That'll do it.
Yeah, that'll do it.
Yes. So, all right, guys. Well, that is Legally Live. We've got McKinley here, Nick Starro, Trial Watch. He's going to be doing Young Thug. McKinley, I'm going to have stuff coming up, but that's to be determined, it sounds like. And then, guys, like I said, if you... Oh.
I'm not on drugs, guys. Not on drugs. I'm just weird.
Not right now.
Not at the moment.
It's not Thursday night yet.
Right.
Yeah.
Huh?
Only peyote only in days that end in Y. But guys, we'll be over at potentiallycriminal.locals.com starting at 8:30 or right around that time. We'll just be hanging out. So I will see you guys then. And Brandon, I will we'll get this one killed off for you, and then we'll probably have a couple more drinks over there and just relax and get ready for the week. So thank you again, guys. Thank you everybody's been here, and we'll see you guys around. Bye.
Bye.